Audiobooks from Disha NGO Chandigarh. Today's book is
Awaken and Transform into Cyber Czars, written by Amarinder Sharma.
यह रिकॉर्डिंग केवल दृष्टिबाधितों के लिए दिशा रिकॉर्डिंग स्टूडियो चंडीगढ़ में ध्वनि अंकित की गई है। इसमें वॉलंटियर्स द्वारा स्वर दिया गया है। यदि आप भी दृष्टिहीनों की सहायता के लिए अपना समय एवं स्वर देना चाहे तो कृपया दिशा एनजीओ के फ़ोन नंबर 9041222282 यानी 9041222282 अथवा ईमेल disha.chandigarh@yahoo.com पर संपर्क करें। धन्यवाद।
This book has been recorded by NGO Disha, the harbinger of social change and development at Chandigarh Disha Recording Studio, for the use of blind. The book titled Awaken and Transform into Cyber Czars, written by Amarinder Sharma, is presented by Parnish, Shiv, Dhiman, Arshdeep, Kaur, Apeksha, Sharma, Astha and Tanisha, Garg. About the author. Amarinder Sharma is currently serving as Chief Judicial Magistrate cum Secretary, District Legal Service Authority, Chandigarh. During his present tenure, the District Legal Service Authority, Chandigarh was adjudged as Best Zonal DLSA in recognition of commitment and the excellent work done in legal services by National Legal Service Authority on 9/11/2016. And was awarded by Honorable Mr. Justice T.S. Thakur, the then Chief Justice of India. He also received the Certificate of Recommendation by Chandigarh Administration for Meritorious Service on 26/1/2017. He cleared his judicial examinations in the first attempt into the year 2007 and joined as Judicial Magistrate, First Class in the year 2008 at Pehwa. In his tenure so far, he has served as Judicial Magistrate, First Class Kurukshetra, Principal Magistrate, Juvenile Justice Board Ambala, Railway Magistrate Haryana, and Chief Judicial Magistrate Zind before his present posting. Amarinder Sharma has completed his 5-year integrated law course from prestigious ILS College, Pune. The college was established in the year 1924 and includes in its notable alumni Honorable Mr. Justice Y.V. Chandrachud, former Chief Justice of India, and Honorable Mr. Justice P.B. Gajendra Gadkar, 7th Chief Justice of India. During his education, he achieved the distinction not only being the topper of his college but also standing first in Pune University, which comprised of more than 13 law colleges. He was given special recognition for his outstanding performance by Shri Vilasrao Deshmukh, who served 2 terms as Chief Minister of the state of Maharashtra. Amarinder Sharma has done his Masters of Law from Kurukshetra University, completed his diploma in Consumer Protection Law from Institute of Advanced Legal Studies IALS, and Diploma in Comparative Cyber Law from Asian School of Cyber Laws. He is a fittest enthusiast with a brown belt in Shaolin, Shotokan, Karate, Do. He has represented his school in various karate and swimming competitions.
Dedicated to my grandfather P.T. H.S. Sharma and my IKI-GAI. Forward, we Chief Justice Punjab Haryana High Court Chandigarh cum Parnish Chief State Legal Service Authority UT Chandigarh. We live in an increasingly interconnected world. Large, it is technology has shrunken the world. This interconnectivity has urged in huge economic benefit by bringing inconvenience and speed to both our interaction and transaction. Yet all of its advantage increased connectivity also bring a significant high risk of fraud, financial theft, identity theft, and online abuse. While these risks are brought to the forefront when we read about cyber attacks on the large corporations and governments, the general populace, it has much higher risk when given the lack of knowledge about cybersecurity. With the increase in the number of misuse of technology in the cyberspace, it is also on the rise with new type of cyber crimes across the globe. Moreover, the growth in electronic commerce and online share trading has led to an unusual rise of cybercrimes. This threat can only be mitigated by the multi-pronged approach, including enacting laws that cover the gamut of cybercrimes and effective law enforced machinery and raising awareness about those law and personal cyber hygiene. With the Information Technology Act 2000, we have laws governing the space. This book by Shri Amarinder Sharma serves to focus on the last approach. The author, under the State Legal Service Authority UT Chandigarh, has covered the crucial aspect of cybercrime and corresponding cyber laws, which would help generate awareness among the cyber users. S.J. Wazifdar, Punjab and Haryana High Court, come Executive Chairman, State Legal Service Authority UT Chandigarh. Message: the information revolution is the key event of this country. The import of information technology hardly needed any emphasis. The conventional method of working, experience, thing, experimental, and even shopping as well as bank dealing have been completely transformed because of the internet. So has equally transformed the nature and manner of crime from the conventional one to the crime involving computer, and therefore the fast pace of changing crimes need to work in tandem and existing law. The future progress of cyberspace will greatly depend on the extent of safety and protection which would be afforded by strong laws. The bridge between technology striving at fast pace and the existing law need to be filled up so that a strong returns is in the place. The Information Technology Act 2000 find its genes in the Unicentral Model Law on Electronic Commerce. The existing provision of the IT Act placed the Indian law at the forefront and illustrate the evolving nature of Indian law in the internet age. With digitalization of government offices and even courts, the voluminous paper record are been converted into soft copy. Judgment and daily order are available online. In such circumstances, the basic awareness of cyber law and cyber crimes is a mandate. Act 39A engrafts in our constitution loudly object of making justice available to all irrespective of the vast economic and social and other disparities. This objective cannot be achieved unless there is a mechanism to generate appropriate awareness with regard to the changing nature of crimes. The idea is to optimize the cyberspace use while minimizing this new species of crime, the cybercrime. It has been immense pleasure of having the occasion to go through this comprehensive piece of work authored by Shri Amarinder Sharma on the concept of cyberspace. The work addressed the legal issue of the internet age. The author has addressed the very basic and key elements of Information Technology Act pertaining to cybercrimes under the Legal Service Authority UT Chandigarh, which would surely prove valuable to in catering of student, teacher, legal literacy club, legal aid clinic, paraclinic volunteer, and above of all, the common man. Suryakant, Member Secretary, Haryana Superior Judicial Service, Chandigarh. Message: information technology has totally transformed the way of the total life. Initially, it is a tool being used in science, engineering, and technology alone, but slowly and gradually it has touched the life of everyone in day-to-day transactions. From everything going on the e-booking platform to our immense involvement with social media, information technology has completely blanketed us in every aspect of life possibly. But the problem of making a virtual world of one set is aligned to the problem with projecting ourselves on a cyber world. There is no end of virtual space in which a seek stimulation, but they are very unless the prenuptial simulation without satisfaction becoming impressing. Cyber attack have become a permanent fiction on the international scene because they have become easy and cheap to launch. The information warfare and pushing scams all over become so prevalent with the introduction of demonetization and every mode of transaction becoming internet linked. The risk of exploitation and misuse of personal information has increased altogether. As noted by Barack Obama, the cyber world is a sort of wildness, and to some degrees, we are asked to be a sheriff. So, taking the baton in our hand, it is the need of our hour to link the cyber world with the ethical law to prevent this misuse. It is necessary to become an informed audience and spread the awareness of cyber law to over everyone, with from the student to businessman. The idea of Information Technology Act 2000 and Article 39A of the Constitution is to optimize the cyberspace while minimizing these new species of cybercrime. This book by Shri Amarinder Sharma on the concept of cybercrime addressed the spectrum of the legal issue of the internet today. He talked about the basic element of Information Technology Act and cybercrime under the aegis of Legal Service Authority, Union Territory Chandigarh. Mahavir Singh. Preface. The present book signifies the journey of student who is in the continuous process of learning. It is born out of the realization that each one of us in the legal fraternity owns a social responsibility to our community, a portion of which I hope to discharge through the medium of this book, attempt to make student, paralegal, volunteer, practicing advocates, and all the other stakeholders aware of the cybercrime. How unknowingly a single step in cyberspace can lead to a cycle of crimes. My trust with the law has made me discern how many young citizens of our nation are alarming unaware of the cyber world, despite their even increasing association with it, having interaction with more than 1,000 students from various schools, colleges, and universities. I realize how a basic preparatory knowledge of these crimes can be a huge step toward becoming a more informed cyber user. As the average web user is getting younger, more and more children are falling prey to cyber crimes. The recent trend of online fraud, cyberbullying, cyber suicide, and threat due to online games are clear indicator that technology is being utilized as a weapon far more efficient than our conventional notion of crimes. Young people who otherwise couldn't dream of committing a crime in the real world are unknowingly in their virtual world stealing other people's data, vandalizing websites, taking down server, breaking the law, and causing substantial damage to the victim. As they say, prevention is better than cure. The present work is the modest effect elaborating on how certain precautions or basic knowledge can prevent the young generation from being victim of cybercrime. The recent case of death of young children due to the online game Blue Whale was a strong stimulus and triggered me to undertake the present study. With the infinite argumentation of the cyber world in the future, the state's legal service must expand their reach in providing legal aid and support to cases where either the victim or the accused of such a crime seek legal help and aggro. We need to train all our volunteers and increase our capacity to cope with this new trend as well as raise awareness regarding these crimes. As a part of Legal Service Authority of Chandigarh, I urge the advocates and paralegal volunteer to be prepared for the information revolution. The coming times would require greater involvement from our side in cases involving the Information Technology Act 2000. Our responsibility is an important one and must be fulfilled with great sensitivity, which is possibly only if we wake up and transform the cyber czar. This book explores the manner in which a whole gamut of law must adapt themselves to usher in the information age. Amarinder Sharma. Content. Introduction. Page number 1. What is cybercrime? Page number 5. What is cyber law? Page number 9. Key and notion. Page number 13. The Indian experiences. Page number 29. Overview of Indian cyber law, page number 35. Rules and government policies, page number 51. Species of cyber crimes, page number 65. Different type of cyber crimes, page number 73. Penalties, compensation and adjudication, page number 95. Liabilities of intermediaries, page number 107. Offences, page number 119. Section 66A, page number 135. Section 66B, page number 139. Section 66C, 143. Section 66D, page number 145. Section 66E, page number 147. Cyber Terrorism and Compact Mechanism, page number 151. Cyber Pornography and IT Act, page number 161. Cyber Crime in the News, page number 183. The Blue Whale Challenge, page number 197. Conclusion, page number 201.
Introduction. The future depends on what we do in the present. Mahatma Gandhi. What is crime? A crime is an unlawful act which is punishable by law, although the term crime does not have a uniform and a universally accepted definition. The most popular view is that an act in the crime, if it is declared as such as the relevant and applicable law, to be normally classified as a crime, the act of doing something criminal must be accompanied by the intentions to do something criminal. The initial outburst of criminal jurisdiction came into existence in India from the time of Manu. In the category of crimes, Manu has recognized assault, theft, robbery, false evidence, slander, criminal branch of trust, cheating, adultery, and rape. In Western jurisdiction, however, the notion of crime seems for Roman law. In modern times, the crimes as well as the nature of the crime have multiplied in an extraordinary manner. Various statuses have been enacted imposing different kinds of penalties, punishments, and also emphasis on other duties and liabilities. The Indian Penal Code and Criminal Procedure Code 1973 are considered the bedrock of Indian criminal jurisprudence. While the Penal Code deals with offences and indicates what happens, will accord an excuse for offence to the charge of an offence being a substantive law. On the other hand, the Code of Criminal Procedure prescribes the procedure being the adjective law. Preeminent mental statement. It would be further of import to mention the two significant mental elements and play a crucial and consequential role in the criminal law. Intention. Criminal intention refers to the design or the determination of doing an act which is forbidden by criminal law. The term intent has been defined in Canadian case law by a landmark judgment of the Supreme Court of Canada in the case of R.V. Mohan, a judgment on the use of expert in trial testimony. It explains the term intent as the decision to bring about the prohibited consequence. In criminal law, intent is one of the three classes of mens rea that is necessary to constitute a crime, as opposed to a crime involving strict liabilities. A key principle which has to be taken into account to refer intent from the conduct of a person to a probable effect of what conduct. As a general rule, every sane person is presumed to intend the necessary or the probable consequences of the act. Undoubtedly, the said presumption is not fully conclusive and has to be proved in the court of law at the touchstone of every other evidence. Mens rea or guilty mind is one of the fundamental principles of English criminal jurisprudence. It implies that a crime is not committed if the mind of the person doing the act is questioned is innocent. It is said that the intent and the act must both occur to constitute the crime. This is laid down in the old age Latin maxim, actus non factum reum nisi mens rea. The definition of every crime contained either in express terms or by the implications of proposition as in the state of mind. The general rule, therefore, under the common law is the ignorance of the law or a mistaken of law is no defense to criminal prosecution. It would be germane to refer in the case of Severance versus D. Redson, whereas within it has been held that mens rea is an essential ingredient of every offensive expert with their three cases. Number one, offences not criminal in the real sense but which in the public interest are prohibited under the penalty. Number 2, public nuisance. Number 3, cases criminal in form which are really only a summary mode of enforcing a civil law. It is as a consequence relevant to bear the mind under the Indian Penal Code. Definition of various offences have been expressed, provided which define whether any action has been done intentionally, voluntarily, knowingly, dishonesty, etc. Apropos only limited and exceptional cases of offensiveness can be committed without a guilty mind. Chapter 2, what is cybercrime? The goal of education is the advancement of knowledge and the disimplementation of trust. John F. Kidney. What is cybercrime? Having elaborated on the concept of crime and the essential mental elements involving crime, it is contiguous to deal with the concept of cybercrime, considering that with each passing day, the cyber attack was unceasingly becoming more and more sophisticated. Cybercrime, also sometimes called computer crime, is an illegal action that involves a computer or network connecting device. The definition of cybercrime can be broken into two categories and defined as cybercrime in a narrow sense, any illegal behavior directed by means of electronic operation that targets the security of computer system and the data processed by them. Cybercrime in a broader sense, any illegal behavior committed by means of or in relation to a computer system or network, including such crime, or illegal possession of distribution of offensive information by the means of computer system or network. Therefore, a cybercrime is a crime that involves a computer and a network. The computer may be used in the commission of the crime, or it may be the target. These offenses may be committed against individual or group of individuals with a criminal motive of intention to harm them or cause any loss. Common type of cyber crimes include online bank information theft, identity theft, online predatory crimes, and unauthorized computer access. More serious crimes like crime terrorism are also of a significant consternation. A cyber countermeasure, on the other hand, is defined as any action, process, technology, device, or system that serves to prevent or mitigate the effect of the cyber attack against the computer service, network, or associated device. A number of such countermeasures exist that can be effectively implemented in order to combat cybercrime and increase cybersecurity. Who commits cybercrime? Number 1, insider, disgruntled employee and ex-employee, sports lover. Number 2, hackers, individuals who attack into network with malicious intent. Number 3, virus writers, individuals who pose serious threats to the network and working system worldwide. Number 4, foreign intelligence that use cyber tools as part of the serving for espionage and can pose the biggest threat to the security of nation. Number 5, terrorists. Terrorists use cyber attacks to instill fear, steal strategical confidential data, raise illegal funds, spread propaganda, etc. Number 6, common citizenry. Sometimes common people, especially young students, in an attempt to prove that they know various tips and tricks in the cyber world, end up effecting acts which come under the prevalence of cyber crime. Cyber law jurisprudence. All I knew about the world's cyberspace when I coined it was that it seemed like an effective buzzword. It seemed evocative and essential, meaningless. It was suggestive of something, but we had no real semantic meaning, even for me, as I saw it emerge on the page. William Gibson. Cyber jurisprudence, like any other jural science, is a study of law related to the cyber world. Jurisprudence studies the law of a concept of law and the effect of social norms and regulations on the development of law. Both these terms, that is law and jurisprudence, bear a profound interrelationship. Jurisprudence is nothing but a set of majority accepted principles of a given society. This analogy is referred in the inception of only the earliest system of laws in the world, how jus civil and the jus gentium were merged into the broad stream of Roman law. They're designed to germinate all the legal. Chapter 3. What is cyber law? Our greatest weakness lies in giving up. The most certain way to succeed is always to try just one more time. Thomas Alva Edison. What is cybercrime? Cybercrime is the law governing cyberspace. The cyberspace is a very comprehensive and overarching term and includes computer systems, software, data storage devices such as hard disk, USB disk, etc., the World Wide Web and its millions of websites, emails, and even electronic communication devices such as laptop, mobile, etc. Cyber law encompasses law related to cyber crimes. Number 2, electronic and digital signatures. Number 3, intellectual property. Number D, data protection and privacy. The primary source of cyber law in India is the Information Technology Act 2000. The predominant purpose, as enlisted in the preamble, is to provide legal recognition for transaction turning to electronic commerce, with evolved the use of alternate to paper-based method of communication and storage of information, as well as the facilitate the filling of the electronic records with government agencies. The Information Technology Certifying Authority Rules 2000 also came into enforcement at the same time as the Act. These rules prescribe the eligibility, appointment, and working of certifying authorities. These rules also lay down the technical standards, procedures, and security methods to be used by the certifying authority. These rules were amended in the year 2003, 2004, and 2006. The Information Technology Certifying Authority Regulations 2001 came into force on 9 July 2001. They provide further technical standards and procedures to be used by a certified authority. Time stands testimony to the fact that the efficiency of law is best tested during a conflict. However, these conflicts are there rise to the need of law. Just as we require laws, rules and regulations to govern our interpersonal relationship and the social society, we also require rules to govern the conduct of persons in cyberspace. When conflicts arise in cyberspace, we need cyber laws in place to re-equip the victim and restore others to the society. The need for cyber laws is especially important as cyberspace is an intangible dimension which needs a tenacious mechanism to regulate conduct, with conventional law certainly falls short to regulate, synchronize, and govern the ever-growing virtual world. Within the cyberspace handles and the elephantine volume of traffic, billion of emails, chats, electronic money transfer, etc. are being carried out every minute. Further, considering that the cyberspace is preliminary, open to participate by all, it bespeaks and the undeniable needs of the appropriate legal framework. Chapter 4, Key Terms and Notions. The best way to predict our future is to create it. Abraham Lincoln. To better understand the concept of cyber law, we must first attempt to unravel some definitions of key terms and notion. Computer. According to Section 2A(1) of the Information Technology IT Act, computer being an electronic magnet, optical or other high-speed data processing device or system which performs logical, arithmetic and memory functions by manipulation of electronic, magnetic, or optical impulses and includes all input-output processes, storage, computer software, or communication facilities which are connected or related to the computer in a computer system or computer network. Therefore, a computer has the following characteristics. Number 1, it is a high-speed data processing device or system. Number 2, it may be electronic, magnetic, or optical. Number 3, it performs logical, arithmetic, and memory functions. Number 4, these functions are performed by manipulation of electronic magnets or optical impulses. The term computer embraces within its definition: number 1, all input facilities; number 2, all output facilities; number 3, all processing facilities; number 4, all storage facilities; number 5, all computer facilities, software facilities; number 6, all communication facilities which are connected or related to the computer in the computer system or network. Diebold system versus commissioners of commercial taxes. In an interesting case of Diebold system private limited versus the commissioner of commercial taxes, the Honorable Karnataka High Court held the automated tenure mechanism are not computers but an electronic device under the Karnataka Sales Tax Act 1957. Diebold System Private Limited and manufacturer and supplier of ATM has sought a clarification from the Advanced Ruling Authority ARA in Karnataka on the rate of tax application. Under the Karnataka Sales Tax Act 1957 on the sale of these machines, the majority view of the ARA was to classify ATMs as computer terminable liable for 4% basic taxes as they would fall under entry 22B of Part C of the second schedule to the Karnataka Sales Tax KST Act. The chairman of the ARA, on the other hand, dissented from the majority view. In his opinion, ATMs would fit into the description of good electronics part and accessories, therefore they would just attract 12% basic tax and would fall under entry 4 of Part E of the second schedule of the KST Act. However, the Commissioner of the Commercial Taxes was of the view that the ARA rules were erroneous and passed an order that ATMs cannot be classified as computer terminals. The Honorable High Court of Karnataka acknowledged that the IT Act provided an enlarged definition of computers. However, the court held that such a wide definition could not be used for interpretation of taxation related laws such as the Karnataka Sales Tax Act 1957. The court also held that the ATM is not a computer by itself. It is connected to a computer and performs the task required by the person using these machines. The computer is connected electronically to make ATMs that may be located at some distance from the computer. Data. According to Section 2.1 of the IT section, data means the representation of information, knowledge, facts, concepts, or instructions which are being prepared or have been prepared in the formation manner and is intended to the process is being processed or has been processed in a computer or a computer network and may be in any form including computer printout, magnetic or optical storage media, punched cards, punched tabs are stored internally in the memory of the computer. Therefore, data is a representation of information, knowledge, facts, concepts, or instructions. Number 2, prepared or being prepared in a formalized manner. Number 3, processed, being processed, or sought to be processed in a computer. Data can be many forms such as number 1, computer printouts, number 2, magnetic storage media, example hard disks, number 3, optical storage media, example CD, ROM, DVDs, VCDs, number 4, punched cards or tabs, that is a paper card in which holes are punched, computer software and hardware. Computer software is a general term that describes a collection of computers programs, procedures, and documentation. Computer hardware, on the other hand, consists of a physical device that can store and execute computer software. System software can be of various types, such as operation system that form the platform for all other softwares on a computer, device drivers that allow computer program to interact with hardware devices such as printers, scanners, etc. Number 3, programming tools which help programmers to develop and test other programs. Number 4, compilers which compile the source code into the object code. Number 5, linkers which link object code, files and libraries to generate an executable file. Number 6, utility software that helps manage and run the computer hardware, operating system or application software. Application software including number 1, word processor, example Microsoft Word Pages. Number 2, spreadsheets, example Microsoft Excel, numbers. Number 3, presentation software, example Microsoft PowerPoint, Keynote. Number 4, media players, example Windows Media Player, QuickTime Player. Number 5, games, example Need for Speed, Age of Empires. Number 6, forensic software, example WinHex, X-ray forensics. Number 7, encryption software, example Pretty Good Privacy of PGP. Number 8, internet browsers, example Mozilla Firefox, Google Chrome, Safari. Number 9, FTP client, example 5FTP and 100 of other type of softwares. Computer system, according to section 211 of the IT Act, computer system means a device or collection of devices including input and output support devices and excluding calculators, which are not programmable and capable of being used in conjunction with external file with contained computer program, electronic instruction, input data and output data that perform logic, arithmetic, data storage and read-write, communication, control and other functions. Therefore, a computer system has the following characteristics. Number 1, it is a device or collection of devices which contain data or program. Number 2, it performs function such as logic, storage, arithmetic, etc. Number 3, it includes input and output support system. Number 4, it executes non-programmable calculators. Computer network, according to section 2(1)(j) of the IT Act, computer network means the interconnection of one or more computer systems or communication device through number 1, the use of satellite, microwave, interstitial line, wire, wireless or other communication media and terminals. Terminals or a complex consist of 2 or more interconnection computers or communication devices, whether or not the interconnection is continuously maintained. Therefore, a computer network is the interconnection of one or more computers through number 1, a satellite. Satellite internet access is internet access provided through communication satellites. Moderate consumers satellite internet services is typically provided to individual users through geostationary satellites that can offer relatively high-speed data. It is an arrangement in which the outgoing and incoming data travels through a satellite orbiting the Earth. Number B, microwave. The term microwave refers to the electromagnetic radiations with a wavelength ranging from 1 meter to 1 millimeter, frequencies between 300 megahertz 100 centimeter and 300 gigahertz 0.1 centimeter. The prefix micro in microwave is not meant to suggest a wavelength in the micrometer range. It indicates that microwaves are small compared to radio waves, which were used prior to microwave technology. C. Terrestrial line. Terrestrial line include fiber optical cable, telephone lines, etc. Number D, other communication media. Communication media refers to any instrument or media that facilitates the transfer of data as between a computer and peripheral or other two computers. Other laws in which two computers can be connected include cable hubs, switches, etc. According to section 2(1)(a) in the Act, The term assess within the grammatical variations and cognate expression means gaining entry into a computer system or computer network, instructions, a logical, arithmetic, or memory function resource of the computer system, or computer network. Number 3, communication with a logical, arithmetical, or memory function resource of a computer system, or computer network. Addressee. Section 2(1)(b) of the IT Act defines the term addressee, which means a person who is intended by the originator to receive the electronic records but does not include any intermediary. In this definition, it is apparent that the three key terms have been used, that is, originator, intermediator, or and addressee. The one who transmits any message to the other person is an originator. An electronic message is a digital or computer-based information. Any person who receives the electronic record is the one who is intended by the originator to receive such electronic records. Therefore, an addressee is a person to whom the originator of an electronic record intends to send any data, record, etc. in any electronic form. However, any person who might receive, forward, or copy the data message on the source of transmitter, or who provides any service with respect to the message being an intermediary, is not included in the definition of addressee. Cyber cafe. The definition of a cyber cafe under section 2(1)(NA of the IT Act was inserted by the Information Technology Amendment Act 2008. It defines cyber cafe as any facility where access to information internet is offered. Number 2, by any person in the ordinary course of business to the member of the public. The word facility entails any commercial establishment which offers internet access to the general public. However, it does not include any education or academic institutions, which is restricted to any study and teachers only. With the intersection of section section 2(1)(NA, cyber cafes are now regulated by the profession of the IT Act 2000. The definition so provided is a combination and extensive definition, and the word used in the definition, that is, in the ordinary course of business, further find its coercive under section 16 and 32(2) of the Indian Evidence Act 1872. Furthermore, the Information Technology Guidance of Cyber Cafe Rule 2011 provide for the mandatory registration of cyber cafe through a registration agency. Cybersecurity. Section 2(1)(NB) of the IT Act 2000 was also inserted by Information Technology Amendment Act 2008. It defines cyber security as protecting information equipment, devices, computer resources, communication devices, and information stored within the authorized access, use, disclosure, disruption, modification, or destruction. The protection of computer and computer resources is one of the most cardinal elements, as they are prone to theft, worm, and unauthorized use. Computer security, therefore, is becoming progressively important, and the IT Act empowers the central government to make rule governing monitoring and collecting of traffic data to enhance cybersecurity. The central government accordingly notified the Information Technology Procedure and Safeguard for monitoring and collecting traffic data and information rules. Intermediary. The term intermediary is currently one of the most talked about term in the Act these days, owing to the plethora of cases and intermediate responsibility. The definition of intermediary underwent an amendment in 2008. The current definition under section 2(1)(W) of the IT Act defines an intermediary with respect to any particular electronic records as any person who on behalf of any other person receives, stops, or transmits that record or provides any service with respect to that record. The term includes telecom service provider, network service provider, internet service provider, web hosting services provider, search engine, online payment sites, online auction sites, online marketplace, and cyber cafes. difference between the old and new definition. The current definition of intermediary completely changes the earlier definition as it specifically incorporates telecommunication service provider, network service provider, internet service provider, web hosting service providers, search engine, online payment sites, online auction sites, online marketplace, and cyber cafes. Moreover, the use of word any person signifies that both professional and non-professional intermediary are included in it. Beside the intermediary, many other also provide and service which may include value-added services such as formation, translation, record, authentication, certifying, etc. Law. Section 21Y of the IT Act provides for the non-exhaustive definition of law that includes number 1 an act of parliament, number 2 an act of state legislature, number 3 the ordinance promulgated by the president of India, number 4 ordinance promulgated by the governor of India, number 5 regulations made by the president under article 240 of the constitution of India, number 6 bills enacted as president's act under Article 357(1)(a) of the Constitution of India. The Information Technology 2000 was passed by the Parliament and rules were made by the central government under Section 87 of the Act. All these are covered under the definition of the term law. Chapter 5 The Indian Experience. The roots of education are bitter, but the fruit is sweet. Aristotle. History of the Internet and the World Wide Web. The history of the Internet commenced with the development of electronic computers. The Internet essentially referred to a global system of interconnected computer networks. It is a network of networks that consists of billions of private, public, and other networks that are connected by a copper wire, fiber optic cables, wireless connections, and other technology. The initial concept of packed network originated in several computer system laboratories in the United States, United Kingdom, and France in the 1980s. Research at the Conseil European pour la Richard Nussler, popularly known as CERN, in Switzerland, by British computer scientist Tim Berners-Lee, resulted in the invention of the World Wide Web. Linked hypertext documents into an information system accessible from any mode of the computer. Although both terms, the Internet and the World Wide Web, are often used without much distinction, however, both implies different meaning. The Internet for a global data communication system. In juxtaposition to it, the World Wide Web is a collection of interconnection documents and other web sources which are interlocked by hypertext links and can be accessed by the Internet. Tim Berners-Lee invented the World Wide Web in 1987 and he wrote the first web browser computer program in 1999. The World Wide Web is a primary tool used by billions of people to interact with the Internet. Web pages are primarily text documents formatted and annotated by hypertext markup language (HTML). The World Wide Web function as application layer protocol, and viewing a web page of the World Wide Web normally begins by typing at the Uniform Resource Locator URL, equally termed as a web address, into a web browser, or by following a hyperlink or that page or resources. The web browser that initiates a server series of background communication matches to fetch the display and required page. Many host names used as the World Wide Web begins with www. The host name of a web series is often www in the same way that it may be NNTP of the USCNet new server for FTP or file transfer protocol servers. Cyber law in India. As mentioned in the preceding chapter, cyber law in India are incorporated under the Information Technology Act 2000, which came into force on October 17, 2000. The main purpose of the act is to provide legal recognition to electronic commerce and to facilitate the filling of electronic records with the government. The following Act rules and regulations are covered under Indian Cyber Laws: Information Technology Act 2000, Information Technology Rules 2000, Information Technology Rules 2004, Information Technology Regulations 2001. Need for cyber laws in India. Our country has a well-defined and well-organized legal system in place. There are various statutes and arrangements which act as a guided light to resolve the complex regarding entanglement. India has one of the oldest legal systems in the world. The history of the present judicial system may be cracked back in the year 1726, where it's a charter was issued by the King George I for bringing about important changes of the judicial administration of the presidency town of Bombay, Calcutta, and Madras. The Constitution of India is the lengthiest constitution in the world and acts as a grandrunner with all other laws deriving the validity from it. We have inter alia the Indian Penal Code 1860, the Indian Evidence Act 1872, the Bankers Book Evidence Act 1891, the Reserve Bank of India Act 1934, etc. However, the advent of the internet browser about various unforeseen circumstances which have added multiple layers of complexity to social interactions and consequences our legal system. However, we live in a world where while sitting in the closed room, a country X, a web browser in country Y would be hacked, resulting in a great financial loss. This is a time when, as per the NDTV reports, 700 government websites that are hosted under government.in and nse.in domain have been hacked by cybercrime since 2012. Therefore, all the existing laws in place could certainly never charter in the phenomena of cybercrime, which effectively metamorphoses the world into a global village. Before the advent of the IT Act, the existing laws in place in India were comparatively enacted way back, keeping in mind the relevant political, social, economic, and cultural scenario of our country. But the magnitude of cyberspace kept expanding in new and different directions in a way that rendered our law illegal equipment to handle the consequent situations people found themselves in. Secondly, the laws of India before the year 2000, even with the most benevolent and liberation interpretation, could not be interpreted in the light of the emerging cyberspace to include all aspects relating to different activities in cyberspace. Hence, the need for enhancement of cyber laws. Thirdly, the internet requirement and enabling the supportive legal instructions in sync with the changing and developing time. These changing times would be well handled and bring about progressive change only when it is supported by a proportionate advance in cyber laws. For example, e-commerce refers to the internet-based industry for buying and selling products or services via electronic means. The feasibility of e-commerce necessitates legal infrastructure capable for supporting the same to enable their bio growth. So all these factors tended with other varied reasons promoted the paramount needs for enacting cyber laws in India. History of cyber law in India. The Information Technology Act was adopted again following a chain of welcome development in the Indian legal system that were triggered by the adoption of the model law of electronic commerce of the United Nations Commission on International Trade Law. Popularly known as the UNCTRICA. On 12 June 1996, the United Nations General Assembly adopted this model law on 30 January 1997 and recommended all states give favorable consideration to the model law while enacting or revising their laws in view of the need for uniformity of laws applicable as alternative to paper-based methods to communication and storage information. Overview of Indians. Chapter Chapter 6 Overview of Indian Cyber Law. Life as if you were to die tomorrow. Learn as if you were to live forever. Mahatma Gandhi introducing the IT Act 2000. The Information Technology Act 2000 is an epoch-making legislation regularization the use of computer system and computer network as also data and information in the electronic format. Their legislation deals with varied aspects pertaining to electronic authentication, digital signature, cyber crimes, and liability of network service providing. This act was amended by Information Technology Amendment Bill 2008, which was passed in Lok Sabha on 22 December 2008, in the Rajya Sabha on 23rd December 2008. It received the assent of the President on 5 February 2009 and was notified by the court of 27/10/2009. The IT Act was developed to promote the IT business, regulate e-commerce, facilitate e-governance, and prevent cybercrime. The Act brought about a number of positive change and development as it attempts to create a dynamic policy that is technologically neutral. This is demonstrated by the Act encapsulated the idea of electronic signature as opposed to digital signature. Entries 12 and 13 of the Union List of the 17th schedule gives legislative compensation to the Parliament with regards to the passing of the present Act. The preamble to the Act. The preamble to this Act sets all the main objectives and the basis introduction to the statute. It proves to be helpful to understand the policy and, most important, the legislative intent. The preamble to the IT Act provides the following: to provide legal recognition for transaction carried out by the means of electronic data interchange (EDI) and other means of electronic communication, commonly known as electronic commerce, to facilitate electronic filing of documents with their government agencies, to amend existing laws like the Indian Penal Code 1860, the Evidence Act 1872, the Bankers Book Evidence Act 1891, and the Reserve Bank of India 1934, to give effect of the aforementioned UNG Resolution A/RES/51/62 and to promote efficient delivery of government services by means of reliable e-recording. For other connections and incidental matters, dispute settlement under the Act. This Act lays down special procedure for deciding the disputes and has created special authorities and courts for purpose of settlement, known as Court of Control, Adjusting Offers, Cyber Play Tribute. Amendments to the IT Act 2000. Every software, however great, comes with the inevitable risk of becoming outdated with time, and thus most of the updated regularly if it is to maintain its relevance. The same stands true for our society as well. In consonance with the changing time and developing technology, the nature of crime we see around us has changed as well. Thus, even with an IT law framework in place, there grew a need to update that existing setup of cyber laws and amended the IT Act 2000 to insert new kind of cyber offences, new definition and named explanation to cement any loopholes which exist in the Act to bring about a positive and enforcement. These lead to the passage of the Information Technology Act 2008, which was made effective from 27th October 2009. The IT Amendment Act 2008 has brought marked change in the existing cyber law framework on several counts. Important changes made by the IT Amendment Act 2008. Number 1. The term digital signature has been replaced with electronic signature to make the act more technological clinical. Number 2. A new section 2A has been inserted to define communication device to mean cell phones, personal digital assistant, or combination of both, or any other device used to communicate, send, or transmit any text, video, audio, or image. Number 3. As discussed on the preceding chapter, a new section has been added to define cyber cafe as a facility from where the access to the internet is offered to any person in the ordinary course of business to the member of the public. Number 4. A new definition has been inserted for intermediary. Number 5. A new section 10A has been inserted to the effect that the contracts concluded electronically shall not be deemed to the an enforcement solely on the grounds that electronic form or means are used. Number 6. The damage of rupees 1 crore prescribed under section 43 of the Act for damage of the computer system, etc., has been deleted, and the relevant part of the section has been submitted by the work. He shall be liable to pay damage. The way of compensation to the person to affected. Number 7. A new section 43A has been inserted to protect sensitive personal data or information processing dealt or handled by a body corporate of a computer resource which such body corporate owns, controls, or operates. If such body corporate is negligent in implementing and maintaining the reasonable security practices and procedure and therefore cause wrongful loss or wrongful gain to any person, it shall be liable to pay damage to by way to compensate to the person so affected. 8. Section 66A to 66F has been added to Section 66 prescribing punishment for offences such as absence, electronic message transmission, identity theft, cheating by impersonation, using computer resources, violation of privacy and cyber terrorism. However, the Supreme Court has now declared Section 66A to be unconstitutional, and its judgment in the case of Shreya Singhal versus Union of India for being violative to the freedom of speech and expressing under Article 12, 19(1)(a) of the Indian Constitution. Section 67 of the Act has been amended to reduce the term of imprisonment of publishing or transmitting obscene material in electronic form to 3 years or to 5 years, and increase the fine therefore by rupees 1 lakh to rupees 5 lakh in case of first conviction. 10. Section 67A, 67B and 67C have also been inserted, while Section 67A and 67B deals with penal provisions in respect of offences of publishing or transmitting of material containing sexual explicit act and child pornography in electronic form. Section 67C deals with the obligation of an intermediary to preserve and retain such information as may be specified for such duration and in such manner and format as the central government may prescribe. 11. In view of the increasing threat of terrorism, the new amendment embraces and amended Section 69, giving power to the state to issue directions to interception or monitoring or decryption of any information through any computer source. Further, Section 69A and 69B grant power to the state of issue direction of blocking for public access of any information through any computer sources and to authorize to monitor and collect traffic data of information through any computer sources by cybercrime. 12. Section 79 of the Act has been monitored. Section 79 of the Act has been modified to the effect that an intermediary shall be excluded from the liability of any third party information, data or communication link made available for hosted by him if number A, its function is limited to providing access to the communication system over which information made available by third parties is transitioned or temporarily stored or hosted. Number B, the intermediary does not initiate to transmission or select the receiver of the transmission and select any modified the information contained in the transmission. Number C, the intermediary observes due eligibles with discharges his duty. However, Section 79 does not apply to the intermediary if the implementatory has conspired or abetted or aided or induced, whether by threats or promises or otherwise, in the commission of the unlawful act or upon receiving actual knowledge or not being notified that any information, data or communication link resided in and connected to the internet resources controlled by the being used to commit an unlawful act. The intermediate falls to explanatory, remove or disable the access to what materials or that resources without vaccinating the evident in any manner. A provision has been added to Section 81, which states that the provision of the Act shall have overridden effects. The provision states that nothing contained in the Act shall be restricted any person from exercising any right conferred under the Copyright Act 1957, Section 79 to 81, Principle of Harmonious Construction. In the interesting case of MySpace versus Super Castles Industrial Limited, the Delhi High Court resolved the confusion between Section 71 and 81 of the ITO service and held they both have to be harmoniously constructed. Section 79 of the IT Act provides a safe harbors of the intermediary by pointing out cases where the intermediary liabilities would not be arising. Difficulty in interpretation arises between Section 79 containing a non-obstructive clause to the effect that the provision of the IT Act would override any law, whereas Section 8.1 lay down the provision of the Copyright Act, which not in many ways be constructed by the IT Act. Thus, using the principle of harmonious construction, the Delhi High Court clarified that the remedies of the intermediates would be available and same shall not standard promulgated by virtue of Section 81 of the IT Act. Number 1. As regards the electronics governance reform in the governmental system were considered imperative, and therefore it was the foremost need of the time that due recognition should be given to the digital signature. Section 4 to Section 8, except Section 6A, begins with the world where any law provides that the information on matter must be written or must be authenticated by affixing the fixed signature on the written document or the presentation of any document in the government or its agencies. In such requirements shall be deemed to have been satisfied if in the place of them the electronic report with electronic/digital signature may be used. Section 3 deals with the digital signature, therefore Section 6A deals with electronic signature. Number 2, Section 8 gives recognition to the publication of official gazette in form of the electronic gazette as a legitimate means of publication. Section 10A and Section 11 to 13 address in the issue of electronic construction. Section 12 is accordingly a pertinent section which has been substituted by Section 10 in 2009, whereas it mentions that the acknowledgement may be given by number A, any communication by the address automated or otherwise, or number B, any conduct of the address sufficient to indicate the originate and the electronic record has been received. Moreover, it clearly states that whether the originator has stipulated that electronic record shall be binding only upon receipt of an acknowledgement of such electronic record by him, then unless acknowledgement has been so received, the electronic record shall be deemed to have been never sent by the originator. Section 16 has given wide power to the central government for security procedure and practices having regard to the commercial circumstances, nature of transaction, and such other related factors as it may consider appropriate. Chapter 9 deals with civil wrong, has fixed the civil liability of the wrong orders, whereas Chapter 9:11 deals with offensive related to computer system and computer network and prescribes punishment of imprisonment of various offenses as enumerated in Chapter 11. Important rules notified under the IT Act: Information Technology, Reasonable Security Practices and Procedure, and Sensitive Personal Data or Information Rule 2011. The Information Technology Electronic Service Delivery Rules 2011, the Information Technology Intermediate Guidelines Rule 2011, the Information Technology Guidelines for Cyber Cafe Rule 2011, the Cyber Ability Tribute Salary Allowance or other term and condition and services of Chairman and Member Rule 2008. Number 6, the Cyber Appetite Tribunal Procedure for Investigation of Misbehavior or Incapacity of Chairperson and Member Rules 2009. 7. The Information Technology Procedure and Safeguard for Blocking for Access of Information by Public Rules 2009. The Information Technology Procedure and Safeguard for Interception, Monitoring and Description of Information Rule 2009. The Information Technology Procedure and Safeguard for Monitoring and Collecting Traffic Data for Information Rule 2009. The Information Technology Use of Electronic Records and Digital Signature Rules 2004. The Information Technology Security Procedure Rules 2004, further amended by Amendment Rules 2015. The Information Technology Other Standard Rules 2003. The Information Technology Certifying Authority Regulation 2001. Number 14, the Information Technology Certifying Authority Rules 2000, further amended by Amendment Rule 2015. Overview of major amendment in other laws. The Indian Penal Code 1860 and the Indian Evidence Act 1872 was amended by the IT Act and its various amendments to keep them in tune with the technological advancement and growing concern of cybercrime. Number A, Indian Penal Code 1860. Respect to the enhancement to the IT Amendment Act 2008, Section 91 of the IT Act was repealed and the provision with regard to Indian Penal Code was mentioned in Part 3 of the Amendment Act. The amendment made by the Indian Penal Code as follows: offensive targeting on a computer research in India. Section 4 of the IPC deals with the code's territory jurisdiction. The 2008 amendment inserted Section 4.3 that expanded the IPC research of any person in any place without the beyond India, permitting an offensive targeting a computer resource located in India. The amendment also modified the section's explanation to state that the expression computer resources shall have been meaningless assigned to it under Section 1K of the IT Act. Concealment of by encryption or information hiding tool. Development in technology permeate in the world of crime tools, a fact exemplified by the following amendment to Section 118 and 119 of the IPC on voluntary conciliation of offences. The 2008 amendment modifies the Section 118 voluntarily concealment of offensive punishable with death and the imprisonment, and Section 119 expanding the nature and of scope instead of the voluntary concealment to include voluntary concealment by the use of encryption or any other information hiding tool. Select electronic signature in Section 464 for the term digital signature where the term electronic signature has been substituted. The Indian Evidence Act 1872 amended related to the Indian Evidence Act were contained in Section 92 and the second schedule of the IT Act 2000. Persuaded in the enhancement of the IT Act 2008, Section 92 of the IT Act was repealed when the provision with regard to the Indian Evidence Act was mentioned in Part 4 of the Amendment Act. Amendment of Section 3 and Section 3 relating to interpretation clause in the paragraph clearing at the end of the word digital signature and digital signature certificate. The words electronic signature and electronic signature certificate has been respectively substituted. Number 2, union of examine of electronic evidence. The purpose of an expert opinion is primarily to assess the court in arriving at the final conclusion. Such a report may or may not be binding upon the court. For the purpose of arriving at the decision, the court takes into consideration the difference between an expert witness or an ordinary witness. As a kind of evidence presented in court changes with the advent of the technology, the rule of evidence must adapt to reflect the compliances of examining the same. Thus, Section 45A was inserted to deal with the opinion of an examiner of electronic evidence. It states that when in a proceeding, the court has to form an opinion on any matter related to any information transmitted or stored on the computer resources or any other electronic or digital form, the opinion of the examiner of the electronic evidence referred in the Section 79A of the IT Act is the relevant fact. Amendment of Section 47A. In Section 47A, number 1, for the words digital signature, the word electronic signature shall be substituted. Number 2, for the word digital signature, certificate, the World Electronic Signature Certificate has been substituted. Number 4, amendment of Section 67A. The Section 67A for the words digital signature, the word electronic signature has been substituted. Number 5, amendment of Section 85A. In Section 85A for the word digital signature, whatever they occur, the word electronic signature has been substituted. Amendment of Section 85B. In Section 85B for the word digital signature, therefore they occur, the words electronic signature have been substituted. Number 7, amendment of Section 85C. In Section 85C for the words digital signature certificate, the word electronic signature certificate has been substituted. Number 8, amendment of Section 70 and 90A. In Section 90A, the word digital signature at both places where they occurred, the words electronic signature has been substituted. Chapter 7, Rules and Government Policies. Develop a passion for learning. If you do, you will never cease to grow. Anthony D. Angelo. National Policy of Information Technology 2012. Information technology is a key driver to the increasing knowledge-based global economy. A knowledge-based economy is a must for leadership. India is an old civilization but a young nation. 800 million people in India fall below 35 years of age. The talent and skilled youth of India is also its driving force. The young Indian workforce is swiftly adapted to the new technology. When it comes to education, the spread of technology and internet penalties are great level. They help quell the divide in terms of the access and quality. Pranab Mukherjee, former President of India. The national policy on IT focuses on the implications of technology-enabled approaches to overcome monetary development challenges in education, health, skill development, employment, and generation, governance, etc. to generate enhanced efficiency across the board in economy. The policy seeks to achieve the twin goals of bringing the full power of information and communication technology within the reach of whole of India and harnesses the capability and human resources to make India a global IT hub and a preferred destination for IT services by 2020. The various objectives of this policy are as under: to increase revenue of IT and IT industries from $100 billion at present to $300 billion by 2020, and expand export from $69 billion at present to $200 billion by 2020. Number 2, to gain effective global market share in emerging technologies and services. Number 3, to promote innovation and research and development in cutting edge technologies and development of application and solution in area like localization, location-based service, mobile value-added services, cloud computing, social media, and utilizing models. Number 4, the encourage adoption of ICTs in key economics and strategic sectors to improve their competitiveness and productivity. Number 5, to provide fiscal benefits to small and medium enterprises and startup for the adoption of IT in value creation. Number 6, to create a pool of 10 million additional skilled manpower in information and communication technology. Number 7, to make at least one individual in every household illiterate. Number 8, to provide for mandatory delivery of and affordable access to all public services in electronic mode. Number 9, to enhance transparency, efficiency, reliability, and decentralization of government, and in particular in the delivery of public services. To leverage ICT for key social sector initiatives like education, health, rural development, and financial services to promote equity and quality. Number 11, to make India a global hub for development of language technology to encourage and facilitate the development of the content accessible in all Indian language and thereby help bridge the digital divide. Number 12, to enable areas of content and ICT application by differently labeled people to foster inclusive development. Number 13, to leverage ICT for expanding the workforce and enabling lifelong learning. Number 14, to strengthen the regulatory and security framework for ensuring a secure and legally competent cyberspace ecosystem. Number 15, to adopt open standards and promote open source and open technology. The present policy deals with various missions and strategies such as creating ecosystem for a globally competitive IT industry, human resource development, promotion of innovation and R&D in IT sector enhances productivity and competitivity in key sectors through ICT, etc. National Cybersecurity Policy 2013. Cyberspace is a complex environment consisting of interactions between people, software, and services, supported by a worldwide distribution of information and communication technology. Cyberspace has emerged as one of the most significant growth catalyst for the economy. However, it is equally vulnerable to a wide variety of incidents. The cybersecurity policy is an evolving task and it caters to the whole spectrum of IT users and providers. It serves as an umbrella framework for defining and guiding the action related to security of cyberspace. This policy aims to create a cybersecurity framework which leads to specific action program to enhance the security posture of country's cyberspace. Objectives: number 1, to create a secure cyber ecosystem in the country, generate adequate trust and confidence in IT system and transaction in cybersecurity space, and thereby enhance adoption of IT in all sectors of the economy. Number 2, to create an assurance and framework for the design of security policies and for promotion and enabling actions for compliance with global security standards and best practice by way of conformity assessment, product, process, technology, and people. Number 3, the strength, the regularity framework and ensuring a secure cyberspace ecosystem. Number 4, to enhance and create national and sectional level 40 and 24/7 mechanism for obtaining strategic information regarding threats to ICT infrastructure, creating scenario for response, resolution, and crisis management through effective preventive, protective response and recovery actions. To enhance the protection and resilience of the nation's criteria of information infrastructure by operating a 24/7 National Critical Information Infrastructure Protection Center and mandating security practices related to the design, sequences, development and operation of the information resources. Number 6, to develop suitable indigenous security technologies through frontier technology resources, solution oriented research, proof of concept, pilot development, transition, diffusion and commercialization, leading to widespread employment of secure ICT products/processes in general and specifically for addressing national security requirements. Number 7, to improve visibility of integrity of ICT products and services by establishing infrastructure for testing and validation of security of push such products. Number 8, to create a workforce of 5 lakh professionals skilled in cybersecurity in the next 5 years through capacity building, skill development and training. Number 9, to provide fiscal benefits to business of the adoption of standard security practices and processes. Number 10, to enable protection of information during handling, storage and transit so as to safeguard the privacy of citizens' data and for reducing economic losses due to cybercrime or data theft. Number 11, to enable effective prevention, investigation and prosecution of cybercrime and enhancement of law enforcement capabilities through appropriate legislative intervention. Number 12, to create a culture for cybersecurity and privacy, enabling responsible user behavior and action through an effective communication promotion strategies. Number 13, to develop effective public-private partnership and collaborate engagement through technical and operational cooperation and contribution for enhancing the security of cyberspace. Number 14, to enhance global cooperation by promotion, shared understanding and leveraging relationships for further the cause of security of cyberspace. The present policy also deals various strategies uh, for creating a secure and assurance ecosystem, creating an assurance framework, encouraging people standard and strategizing the regularity framework. Overview or major rules issued under the IT Act 2000. Number A, the information technology, reasonable security practices and procedures in sensitive personal data or information rule 2011. These rules are regarded sensitive personal data or information and are applicable to the body corporate of any person located within India. They essentially require entities holding sensitive personal information of user to maintain certain specified security standards. The Information Technology Electronic Services Delivery Rules 2011. These rules provide for the creation of the system of electronic delivery of services under the Electronic Service Delivery Rules. The government can specify certain services such as applications, certificate, licenses, etc. to be delivered electronically. Number C, the Information Technology Intermediaries Guidance Rules 2011. These rules provide the rights and responsibilities of intermediaries in India. If the intermediaries follow these rules and exercise proper cyber due diligence, they are entitled to a safe harbor protection. Otherwise, they are liable for various acts or omission occurring at their respective platform once the matter has been brought to their notice. The constitution of these rules were upheld in the Supreme Court of India in the case of Shreya Singhal versus Union of India. Number D, the Information Technology Guidance of the Cyber Cafe Rule 2011. According to the guidelines, Cyber Cafe should register themselves with an appropriate government agency and provide service to user only after establishing their identity. It also deals with maintenance of records such as identity as well as a log of site visit among other provisions. E. The Cyber Appetite Tribunal Salary Allowance and Other Terms and Conditions of Service of Chairperson and Member Rule 2009. These rules provide for the salary allowances and terms of service for the chairperson and member of the Cyber Appetite Tribunal under terms of service. The rule includes provision for leaves, provident fund, oath of office, and secretary declaration of financial or other interest, etc. The Cyber Appetite Tribunal procedure for investigating the misbehavior or incapacity of chairperson and member, Rule 2009. These rules provide for the procedure or investigation of complaints. It initiates prescribes for the preliminary structure of any complaint and further prescribes the detailed procedure for the manner of the investigation. Number G, the Information Technology Procedure and Safeguard for Blocking and Access of Information of Public 2009. The rules provide for the distinction of the officer in the central government for the purpose of issuing direction of blocking for access by the public any information generated, transmitted, received, stored, or hosted in any computer resource. It provides the procedure and the safeguard to be followed by the designated officer. The Information Technology Procedure and Safeguard of Intercept Monitoring and Decryption of Information Rule 2009. These rules explain the procedure and safeguard subject to which such interpretation or monitoring of decryption may be carried out. Number 1, the Information Technology Procedure and Safeguard for Monitoring the Collecting Traffic Data or Information Rule 2009. It contains the procedure for appetite monitoring for communication and the procedural safeguards to be observed in them. Number J, the Information Technology Use of Electronic Records and Digital Signature Rules 2004. These rules deal with the manner and format in which the electronic records should be filed, created, or issued. It also states the manner or method of payment of any fee or charge for filling or creating an electronic record. Number K, the Information Technology Security Procedure Rules 2004. These rules prescribe the provision related to secure digital signature and secure electronic records. Number 1, the Information Technology Other Standard Rules 2003. The rules deals with the standards to be observed by the controller to ensure that the secrecy and security of the digital signature were assured. Number M, the Information Technology bracket Certifying Authority bracket close Regulation, 2001. The regulation detailed the technical standards and procedures to be used by a certifying authority. Number N, Information Technology Certifying Authority Rules, 2000. These rules deal with licensing of certificate authorities and the procedure that need to be compiled by them. It also prescribed the eligibility, appointment and working of certifying authorities. Full stop.
Chapter 8, Types of Cyber Crimes. The true sign of intelligence is not knowledge, but imagination. Albert Einstein. Introduction. Considering the exponential growth of the internet, cyber frauds have become an evil having its redux in the growing dependency of all of us on computers in the modern life. Fighting cyber attacks is like fighting a many-headed monster. Each time a neck is severed, it sprouts a head even fiercer and cleverer than before. Here, an eternal vigil is the prize for our safety. According to UNO expert recommendations, the term cybercrime covers any crime committed by using a computer system or networks within their frameworks or against them. Theoretically, it embraces any crime that can be committed in the electronic environment. Cybercrime is one of the most dangerous of all crimes because of the magnitude of the loss it is causing today, its potential, the ease with which it can be committed, its invisibility, disregard for geographical boundaries, difficulty in investigation, collection of evidence, etc. Internet fraud involves a variety of schemes limited only by the imagination and creativity of a seller with the dishonest intent of deceiving a buyer. Cyber fraud has the potential of hindering the economic and social development of any nation. Types of cyber fraud. There is an extensive variety of cyber crimes and cyber frauds that are prevailing in cyberspace. The main issue with cyber fraud is that it can go unnoticed very easily or undetected and unreported due to the lack of a direct attribution. Techniques such as encryption have become a known way of exchanging data, and the same has become a reason for concern for the investigating agencies. These crimes are precarious, easy to perpetrate, silent in nature, and global in character. Many online frauds reach people in the form of spam messages, usually through emails, but sometimes through text messages, voice messages delivered by internet, or other electronic channels. Many pyramid and work-at-home schemes are also distributed through spam and follow the free advice-free fraud format, requiring upfront payment or investment on the fake promise of a gift, lottery, or high returns. Cyber frauds are regularly becoming more refined and cosmopolitan in nature. The last few years have seen a whirlwind growth of a new practice known as spear phishing, where veracious information about the recipient, such as his/her full name and home address, is included in the phishing email, making it even more convincing. Other variants of fraud rely on the use of identity stolen through technological methods such as pharming, which is a cyber attack intended to redirect a website's traffic to another fake site. Pharming can be conducted either by changing the host's file on a web or by exploitation of a vulnerability in the DNS server software. In a similar such occurrence, in January 2005, the domain name for a large New York ISP, Panics, was hijacked to point to a website in Australia. According to the Norton Cybercrime Report 2012, 66% of Indian online adults have been a victim of cyber fraud in their lifetime. Most of the internet users do not use complex passwords and also fail to change their passwords frequently, which results in leakage of their sensitive information. They are also unmindful of the progression of most common forms of cybercrime, as most of them have no idea that the malware can operate in a discrete fashion, making it hard to know if a computer has been compromised. Preventive measures. It is well said that prevention is always better than cure. The first line of defense to prevent people from becoming online victims is a good education. There are various tips and ways through which internet fraud and cybercrime can be combated. The International Consumer Protection and Enforcement Network (ICPEN), an informal network of enforcement authorities, has launched Fraud Prevention Month, an awareness campaign taking place on a designated month every year. Steps to prevent cybercrimes. Give your personal information publicly on websites. Second, do not enter your credit card, debit card information into any unsecured website or public computers. Third, avoid sending any photographs online, particularly to strangers and chat friends, as misuse of photographs is a common phenomenon. Fourth, always keep a check on the websites that are being accessed by children to prevent any kind of exposure to harassment or violence in children. Fifth, always use the latest and updated antivirus software to protect from virus attacks. Sixth, always keep a backup of your data. Seventh, report lost or stolen credit cards immediately to the company that issued the card by calling the call center. Eighth, if you receive any email asking for your credit card, debit card, immediately delete such email and never respond to it. Ninth, if any call is received seeking confidential details pertaining to any information including credit card, debit card, then never give such details on telephonic call. Rather, approach the concerned bank. 10th, shred or destroy your transaction receipt before you throw them away. 11th, a strong password shall make you stay in the cyberspace much safer. 12th, do not send obscene text images to anyone as it is a cognizable offense. 13th, do not keep your Bluetooth open unless it is in use as it can lead to blue bug attack. 14th, do not give your mobile number or other secret information while chatting as it can lead to stalking. 15. Do not hand over your mobile phone to unauthorized service center to avoid misuse. 16th, ensure network security from external sources by installing firewalls and intrusion detection system. 17th, be aware of what you do while using public Wi-Fi hotspots because even though they are convenient, one must avoid financial or corporate transactions on these networks. 18th, always think before you click on a link or file of unknown origin. Check the source of the message. When in doubt, verify the source and avoid being scammed. 19th, pop-ups can contain malicious software which can trick a user into verifying something. Therefore, always ignore pop-ups offering things like site surveys on e-commerce sites. 20th, only shop online on secure sites. 21. Do not store your card details on any website. 22. Do not ever plug in an unknown USB drive into your PC or laptop. Chapter number 9. Different types of cyber crimes. Cybersecurity is a shared responsibility, and it boils down to this. In cybersecurity, the more systems we secure, the more secure we all are. J. Johnson. Intellectual property crimes. The piracy or counterfeiting of goods such as digital media, luxury fashion, electronic goods, and other manufactured goods are intellectual property crimes. These include software piracy, copyright infringement, theft of computer source, etc. Intellectual property crimes occur on a global scale, making it more difficult for authorities to contain these offenses and prosecute the offenders. Advances in current technologies make it much more easier for production and manufacturing of knockoff products, and the quality of these products is good enough to make it difficult for consumers to differentiate. IP crimes are more generally known as counterfeiting or piracy. There are three main factors contributing to the growth of IP crimes. A. The widespread availability of technology. B. Increased globalization of world trade as a result of more open borders, which facilitates the passage of counterfeit goods across borders. C. The influence of organized crime. Such intellectual property crimes have developed various branches, subcrimes, and disputes which are revolving around the trademark as well as domain names. A trademark is a mark which a person uses to associate himself with the goods or services that he provides. It is a recognizable sign, design, or expression which identifies products or services or a particular source from those of others. The trademarks play a consequential role in attributing quality and authenticity to any product. On the other hand, a domain name is an internet equivalent to a geographical address. They are used to identify one or more internet protocol IP address. For example, the domain name www.microsoft.com represents about a dozen IP addresses. Domain names are used in URLs to identify particular web pages. As per a report of Business Standard India ANI 2017-07-27, in 2017, 330.6 million domain names have already been registered. A top-level domain, TLD, is one of the domains at the highest level in the hierarchical domain name system of the Internet. There are two types of top-level domain names, generic and geographic. Generic top-level domain names. First, .com for commercial use. Second, .edu for educational institutions. Third, .org for miscellaneous and non-profit organization. Fourth, .net for networking providers. Fifth, .gov for government organizations. Sixth, .int for international treaty organization. Seventh, .mil for defense. Geographical top-level domain names end with a two-letter code, which is assigned to each country. Example, in India, .fr, in France, .aus, in Australia, .uk, in United Kingdom, etc. Any individual or any organization can employ a domain name only after having registered for its use. They are common man's language and are actually a proxy for the IP address. They are given on basis of first come, first serve. Second, cyber squatting. Cyber squatting, also known as domain squatting, is registering, trafficking in, or using an internet domain name with bad faith to profit from the goodwill of a trademark belonging to someone else. Therefore, a cyber squatter would book domain names of important organizations, brands, products with the hope of earning money by selling the same at exorbitant rates. The term is derived from squatting, which is the act of occupying an abandoned or unoccupied space or building that the squatter does not own, rent, or otherwise have permission to use. Nissan Motors versus Nissan Computer was a case of alleged cyber squatting between two parties over the use of the name Nissan and the domain name Nissan.com. Nissan Motors considered the use of the name Nissan Computers as cyber squatting. However, since the domain name Nissan was named by Nissan Computer after its owner Uzi Nissan, the claim of Nissan Motors was not accepted. Following the outcome of the case, Nissan Motors uses the name NISSANUSA.com, Nissan USA, for its website in the United States of America. Microsoft versus Microsoft. This was a legal dispute between Microsoft and a Canadian student named Mike Rove over the domain name mikerovesoft.com. This domain name was initially registered by a Canadian student as a part-time web design business. Microsoft alleged it to be a trademark infringement because of its phonetic resemblance to their trademarked corporate name and demanded that he give up the domain name. Thereafter, a settlement eventually arrived, with Mike Rove granting ownership of the domain to Microsoft in exchange for an Xbox and additional compensation. Reference from BBC News: Boy swaps Microsoft for Xbox. Yahoo Inc. versus Akash Arora and ANR. This is one of the first cases where an Indian court dealt with the question of domain names. The present suit was instituted by the plaintiff against Akash Arora and ANR. Seeking for a degree of permanent injunction restraining them, their partners, agents from operating any business and or selling, offering for sale, and in any manner dealing with any services or goods on the internet or otherwise under the domain name yahooindia.com or any other domain name which is identical with or deceptively similar to the plaintiff's trademark Yahoo. The Honorable Delhi High Court held that the plaintiff was able to make out a prima facie case for grant of ad interim injunction, and Akash Arora and ANR. Were restrained from using domain name yahooindia.com or any other domain name which is identical with or deceptively akin to the trademark Yahoo. Titan Industries Limited versus Prashant Kurapati. In this particular case, the Honorable Delhi High Court granted an ex parte ad interim injunction restraining the defendants from using the name Tanisha on the internet or otherwise and from committing any other act which can be rated as passing off as the articles of the defendant to be articles of the plaintiff, Titan Industries. The Honorable Delhi High Court held in favor of the plaintiff and granted an ex parte ad interim injunction restraining the defendant from using the trade name Tanishq or any other name that is deceptively similar and would likely lead to passing off of the business and goods of the plaintiff. Tata Sons Limited versus Ramada Soft. Tata Sons, the holding company of India's biggest industrial conglomerate, the Tata Group, won a case to evict a cyber squatter from 10 contested internet domain names. Tata Sons had filed a complaint at the World Intellectual Property Organization (WIP). The respondent was ex parte. The panel concluded that the respondent owns the domain names. These domain names are confusingly similar to the complainant's trademark Tata, and the respondent has no rights or legitimate interests in respect of the domain names, and he has registered and used the domain name in bad faith. These facts entitled the complainant to an order transferring the domain names from the respondent. SBIcards.com versus Domain Activity Property Limited. SBIcards.com, SBI Cards, was ordered by the World Intellectual Property Organization (WIPO) to be transferred to the Indian company from an Australian entity, name hoping to list Bank of India subsidiary. The panel accepted SBI Card's argument that the Australian company was in the business of buying and selling domain name through its website. Satyam Infoway Limited versus Sifinet Solutions Private Limited. Additionally, it would be gainful to quote the words of Honorable Supreme Court in case of Satyam Infoway Limited versus Sifinet Solutions Private Limited, wherein it was observed that distinction lies in the manner in which the two operate. A trademark is protected by the laws of a country where such trademarks may be registered. Consequently, a trademark may have multiple registrations in many countries throughout the world. On the other hand, since the internet allows for access without any geographical limitation, a domain name is potentially accessible irrespective of the geographical location of the consumers. The outcome of this potential for universal connectivity is not only that a domain name would require worldwide exclusivity, but also that national laws might be inadequate to effectively protect a domain name. Dr. Reddy's Laboratories Limited versus Manu Kasuri and A&R Dot. In Dr. Reddy's Laboratories Limited versus Manu Kasuri and A&R Dot, the Honorable High Court of Delhi held that it is a settled legal position that when a defendant does business under a name which is sufficiently close to the name under which the plaintiff is trading, and that name has acquired a reputation, and the public at large is likely to be misled that the defendant's business is the business of the plaintiff or is a branch or department of the plaintiff, the defendant is liable for an action in passing off. The court also held that it is always not necessary that there must be in existence goods of the plaintiff with which the defendant seeks to confuse his own domain name. Passing off may occur in cases where the plaintiffs do not, in fact, deal with the offending goods. When the plaintiffs and defendants are engaged in common or overlapping fields of activity, the competition would take place and there is grave and immense possibility for confusion and deception. The domain name serves the same function as the trademark and is not mere address, and therefore plaintiff is entitled to equal protection as a trademark. The court observed that the domain name is more than a mere internet address, and for it also identifies the internet site to those who reach it in an internet service. A particular internet site could be reached by anyone anywhere in the world who proposes to visit it. In a matter where services rendered through the domain name on the internet, a very alert vigil is necessary and a strict view needs to be taken for its easy access and reached by anyone from any corner of the world. The trademark, domain name Dr. Reddy's of the plaintiff and DRREDDYSLAB.com, drreddyslab.com of the defendants are almost similar except for use of the suffix lab.com in the defendant's domain name. The degree of the similarity of the marks usually is vitally important and significant in an action of passing off, as in such a case there is every possibility of confusion and deception being caused. Considering both the domain names, it is clear that two names being almost identical or similar in nature, there is every possibility of an internet user being confused and deceived in believing that both the domain names belong to plaintiff, although the two domain names belong to two different concerns. Aqua Minerals Limited versus Mr. Pramod Borse and ANR.com. In Aqua Minerals Limited versus Mr. Pramod Borse and ANR. The Honorable High Court of Delhi held that unless and until a person has a credible explanation as to why did he choose a particular name for registration as a domain name, or for that purpose as a trade name which was already in long and prior existence and had established its goodwill and reputation, there is no other inference to be drawn that the said person wanted to trade in the name of the trade name he had picked up for registration or as a domain name because of its being an established name with widespread reputation and goodwill achieved at huge cost and expenses involved in the advertisement. Nestle India Limited versus Mood Hospitality Private Limited. In Nestle India Limited versus Mood Hospitality Private Limited, the Honorable High Court of Delhi has held that in case of interim relief injunction test of prima facie case as traditionally understood has been replaced. at least in trademark matters, by the test of comparative strengths of the rival cases. This is also in keeping with the requirements of the said Act, in as much as it is not only describes what amounts to infringement, but it also makes provision for what does to infringement. The above mentioned cases evince how cyber squatting as a crime has seeped into the Indian society and commerce. However, in spite of increasing incidences of cyber squatting, there is no adequate law in India to address this major issue. The intellectual property rights laws of our country need to be amended to bring them in tandem with the growing advancement in domain names and trademark related issues over the internet. Hence, there is an overwhelming need to address the issues relating to domain name disputes by the Government of India. Third, phishing. Phishing is a criminally fraudulent process whereby an attempt is made to obtain sensitive information such as password, credit card details, usernames, etc. by any person for malicious reasons, masquerading as a trustworthy person or business in an outwardly official electronic communication, such as an email or instantaneous communication. The term has been picked from the word fishing due to the similar connotation of using a bait in an attempt to catch a victim. Communications purporting to be formed from popular social websites, auction sites, online payment processors are commonly used to lure the unsuspecting. Phishing is typically carried out by email spoofing. Email spoofing is the creation of email messages with a forged sender address. As the core email protocols are not always authenticated, therefore, it is common for spam and phishing emails to mislead the recipient about the origin of the act. Responding to an email to a user by falsely claiming to be an established legitimate enterprise can easily result in an identity theft as a result of the loss of private information. The email directs the user to visit a website and the user is asked to update his confidential communication. However, the said website by itself is a bogus and fake website which is actually set up to steal the secret information. Types of phishing. Spear phishing. Spear phishing directs at specific individuals or organizations. The victim is typically sent an email which appears to be from an individual whom the victim already knows. Attackers may gather personal information about their target to increase their probability of success. This technique is one of the most successful techniques on the internet. As per the report of Economic Times dated November 10, 2008, there has been a sharp increase in phishing attacks on Indian banks. In September-October 2008, the NASSCOM reported over 400 phishing attacks on Indian banks. Moreover, as per a report in The Hindu, India ranks on the list of world's top 15 countries hosting phishing sites which aims at stealing confidential information. Report dated 26 November 2006. Clone phishing. Clone phishing is a particular form of phishing attack whereby a legitimate and previously delivered email containing an attachment or link has had its content and recipient address taken and used to create an almost identical or clone email. The attachment or link within the email is replaced with a malicious version and then sent from an email address spoofed to appear to come from the original sender. Fourth, whaling. The term whaling has been used to describe a phishing attack that is specifically aimed at wealthy, powerful, or prominent individuals. If such a user becomes a victim of the phishing attack, he can be considered as a big fish or alternatively a whale. Whale phishing involves the same tactics used in spear phishing campaigns. With regular advancement, the phishing techniques are becoming more and more sophisticated and strenuous to trace. The attackers try to ensnare the victim by using all cards, including emotional tactics, to take confidential information. In the recent China earthquake donation phishing attack, various phishing attacks were discovered that targeted the donors who wanted to contribute to charity. The phishing sites indicated themselves to be the representative of various authorized agencies and asked the donors to donate on various multiple bank accounts, and as a result, various donations suffered the phishing attack. Anti-phishing. It is the responsibility of one and all to be careful while using the internet, as the attacks of phishing are regular and can go unnoticed, causing momentous harm. Hence, adoption of anti-phishing strategies to protect personal and confidential information is fundamental. The organization and individuals should be educated to train them to recognize phishing attempts and to manner to thwart them. Most of the internet users can avoid phishing attempts by modifying their browsing habits. Most stress that the individual knows should be used and typed rather than using hyperlinks in the suspected phishing message. By the same token, specialized spam filters can reduce the number of phishing emails that reach the mail inbox, and use of such spam filters should be encouraged. Fifth, wishing. Wishing voice or VoIP phishing is an electronic fraud tactic in which individuals are tricked into revealing critical financial or personal information to unauthorized entities. Wishing words like phishing but does not always occur over the internet and is carried out using voice technology. A wishing attack can be carried out by using voice email or landline or cellular telephone. The aim is to access to private, personal and financial information from the public, usually for the purpose of financial gains. 6. Webjacking. This term is derived from the term hijacking. In such offenses, the hacker gains access and control over the website of another. He may even change the information on the site. This occurs when there is a forcible control of a website by cracking the password and later changing it. The actual owner of the website does not have any more control over what happens on that website. Recently, the website of the Ministry of Information Technology was hacked by hackers from Pakistan, and some obscene matter was placed on the website as well. Moreover, the site of Mumbai Crime Branch was also webjacked in the past. 7th, data diddling. It is a method adopted by computer criminals by virtue of which they change the data before or during entry into the computer system, or altering the raw data just before it is processed by a computer and then changing it back after the processing is complete. Using this technique, the accused can manipulate the output, and it is also difficult to identify. Examples of data diddling are forging, misrepresenting, counterfeiting documents, etc. The NDMC electricity bill fraud case that took place in 1996 is a typical example. The computer network was used for accounting of electricity bills by the New Delhi Municipal Corporation. Collection of money, computerized accounting, record maintenance, and remittance in the bank was exclusively left to a private contractor who was a computer professional. He misappropriated huge amounts of funds by manipulating data files to show less receipt and bank remittance. 8th, salami attacks. These attacks are used for the commission of financial crimes. The key here is to make the alteration so insignificant that in a single case it would go completely unnoticed. For example, a bank employee inserts a program into the bank's server that deducts a small amount of money, say Rs 5 a month, from the account of every customer. No account holder will probably notice this unauthorized debit, but the bank employee will make a sizable amount of money every month. To cite an example, an employee of a bank in the USA was dismissed from his job for indulging in salami attacks. Disgruntled at having been supposedly mistreated by his employers, the man first introduced a logic bomb into the bank's systems. Logic bombs are programs which get activated on the occurrence of a particular predefined event. The logic bomb was programmed to take 10 cents from all the accounts in the bank and put them into the account of the person whose name was alphabetically the last in the bank's rosters. Then he went and opened an account in the name of Ziegler. The amount being withdrawn from each of the accounts in the bank was so insignificant that neither any of the account holders nor the bank officials noticed the fault. It was brought to their notice when a person by the name of Ziegler opened their account in that bank. He was surprised to find a sizable amount of money being transferred into his account every Saturday. Being an honest person, he reported the mistake to the bank authorities and the entire scheme was revealed. Ninth, cyber stalking. Stalking is a problem that many problems, especially women, face in real life. The Oxford Dictionary defines stalking as pursuing stealthily. Cyber stalking involves the internet by posting messages, sometimes threatening, on the bulletin boards frequented by the victim and entering chat rooms frequented by the victim, constantly bombarding the victim by emails, etc. Cyber stalking can be a terrifying experience for victims, plus for psychological trauma. It is also considered as a form of cyberbullying, which is a form of harassment using electronic forms of contact. Stalking is a continuous process consisting of series of actions and is a form of mental assault, which disruptively breaks into the world of the victim and causes harassment and abuse. 10th, cyber defamation. The term defamation is used to define the injury that is caused to the reputation of a person in the eyes of a third person. The injury can be done by words, oral or written, or by signs, or by visible representation. The intention of the person making the defamatory statement must be to lower the reputation of a person against whom the statement has been made in the eyes of the general public. Cyber defamation is a new concept, but the conventional concept of defamation is applicable to cyber defamation. It means publishing of defamatory material against another person with the help of computers or internet. If someone publishes a defamatory statement regarding another person with an intention to defame the another person about whom the statement has been made, the act would account to cyber defamation. The harm caused to the person by such action is no doubt irreparable and widespread. The following are the mediums by which offense of cyber defamation can be committed. A. World Wide Web. B. Discussion groups. C. Internet. D. Mailing lists and bulletin boards. E. Email. SMC Pneumatics India Private Limited versus Jogesh Quatra. In India's first case of cyber defamation, Honorable Delhi High Court passed an ex parte ad interim injunction in case of SMC Pneumatics India Private Limited versus Jogesh Quatra, being suit number 1279/2001. In the present case, the defendant Jogesh Quatra started defaming the company by sending derogatory, defamatory, obscene, vulgar, and abusive emails to the managing directors and the sales and marketing departments of the company. Consequently, the Honorable Delhi High Court restrained the defendant from sending such emails and from publishing, transmitting, or causing to be published any information in the cyberspace which is derogatory or defamatory in nature. Chapter number 10. Penalties, Compensation and Education. And those who were seen dancing were thought to be the insane by those who could not hear the music. Friedrich Nietzsche. Introduction. It is extremely imperative for there to be a control mechanism over the cyberspace pertaining to which the horizons are so broad and unending. Legal control actions are crucial to tackle the various problems which are emerging from a continuous expansion of technology. There is always a vast difference between a civil wrong and a criminal law. Chapter 9 of the IT Act deals with civil wrongs and provides compensation for these wrongs. Under the IT Act, the same act of a person may amount to a civil wrong as well as being a criminal wrong. Chapter 9 deals with civil wrongs and has fixed the civil liability on wrongdoers, where Chapter 11 deals with the offences related to computer system, and computer network. Chapter 9 comprises of provisions from Section 43 to Section 47, of which Section 43 and 43A are the material provisions dealing with the concept of civil wrong. It would be appropriate to reproduce these sections here for better understanding of the subject. Section 43 reads as follows. Section 43. Penalty and compensation for damage to computer, computer system, etc. If any person, without permission of the owner or any other person who is in charge of a computer, computer system, or computer network, A. Assesses or secures access to such computer system, computer network, B. Downloads copies or extracts any data, computer database, or information from such computer, computer system, or computer network, including information or data held or stored in any removable storage medium. C. Introduces or causes to be introduced any computer, containment, or computer virus into any computer, computer system, or computer network. D. Damages or causes to be damaged any computer, computer system, or computer network, data computer database, or any other programs residing in such computer, computer system, or computer network. E. Disrupt or causes disruption of any computer, computer system, or computer network. F. Denies or causes the denial of access to any person authorized to access any computer, computer system, or computer network by any means. G. Provides any assistance to any person to facilitate access to a computer, computer system, or computer network in contravention of the provisions of this Act, rules, or regulations made thereunder. H. Charges the services availed of by a person to the account of another person by tampering with or manipulating any computer, computer system, or computer network. I. Destroys, deletes, or alters any information residing in a computer or affects it injuriously by any means. J. Steal, conceals, destroys, or alter, or causes any person to steal, conceal, destroy, or alter, or causes any person to steal, conceal, destroy, or alter any computer source code used for a computer resource with an intention to cause damage. He shall be liable to pay damages by way of compensation to the person so affected. Explanation. For the purpose of this section, I. Computer contaminant means any set of computer instructions that are designed to modify, destroy, record, transmit data, or program residing within a computer, computer system, or computer network, or by any means to usurp the normal operation of the computer, computer system, or computer network. Second, computer database means a representation of information, knowledge, facts, concepts, or instructions in text, image, audio, video that are being prepared or have been prepared in a formalized manner or have been produced by a computer, computer system, or computer network and are intended for use in a computer, computer system, or computer network. Third, computer virus means any computer instruction, information, data, or program that destroys, damages, degrades, or adversely affects the performance of a computer resource or attaches itself to another computer resource and operates when a program, data, or instruction is executed or some other event takes place in that computer resource. Damage means to destroy, alter, delete, add, modify, or rearrange any computer resource by any means. Fifth, computer source code means the listing of programs, computer commands, design and layout and program analysis of computer resource in any form. Furthermore, Section 43A reads as follows. Section 43A, compensation for failure to protect data. Where a body corporate possessing, dealing, or handling any sensitive personal data or information in a computer resource which it owns, controls, or operates is negligent in implementing and maintaining reasonable security practices and procedures and thereby causes wrongful loss or wrongful gain to any person, such body corporate shall be liable to pay damages by way of compensation to the person so affected. Explanation for the purposes of this section. First, body corporate means any company and includes a firm, sole proprietorship or other association of individuals engaged in commercial or professional activities. Second, reasonable security practices and procedures means security practices and procedures designed to protect such from unauthorized access, damage, use, modification, disclosure, or impairment as may be specified in an agreement between the parties or as may be specified in any law for the time being in force, and in the absence of such agreement or any law, such reasonable security practices and procedures as may be prescribed by the central government in consultation with such professional bodies or associations as it may deem fit. Third, sensitive personal data or information means such personal information as may be prescribed by the central government in consultation with such professional bodies or associations as it may deem fit. Section 43 provides penalty and compensation for any damage caused to any computer, computer system, or computer network by unauthorized access, introduction of a computer virus, damage, disruption, or any other type of mischief. If any person is found guilty of contravening this section, he shall be liable to pay damages by way of compensation. Section 43A has been inserted by Act 10 of 2009 in the IT Act and makes mention of various crucial terms such as body corporate, reasonable security practices and procedure, sensitive personal data or information. There are other few provisions in Chapter 9 such as Section 44 which deals with penalty for failure to furnish information, results, returns, etc. and Section 45 which deals with residuary penalty wherein for the contravention of remaining acts which are not covered under Section 43 and 44 any such person shall be liable to pay compensation not exceeding 25,000 rupees to the person affected by such contravention or a penalty not exceeding 25,000 rupees. Furthermore, Section 46 deals with the power to adjudicate, and central government has been authorized to appoint an officer not below the rank of a director to the Government of India or any equivalent officer of the state government for holding an inquiry in the manner prescribed under rules of the central government. Section 47 further provides the factors which have to be taken into account by the adjudicating officer for the purpose of adjudging the quantum of compensation. In order to make the provisions more clear, the same has been reproduced hereunder. Section 44 to Section 47 of the IT Act reads as follows. Section 44. Penalty for failure to inform, etc. If any person who is required under this Act or any rules or regulations made thereunder to a. furnish any document, return, or report to the or the certifying authority fails to furnish the same, he shall be liable to the penalty not exceeding 1,50,000 rupees for each such failure. B. File any return or furnish any information, books, or other documents within the time specified. Therefore, in the regulations, fail to file, return, or furnish the same within the time specified. Therefore, in the regulations, he shall be liable to a penalty not exceeding 5,000 rupees for every day during which such failure continues. C. Maintain books of accounts or records, fails to maintain the same, he shall be liable to a penalty not exceeding 10,000 rupees for every day during which the failure continues. Section 45. Residuary penalty. Whoever contravenes any rules or regulations made under this Act, for the contravention of which no penalty has been separately provided, shall be liable to pay a compensation not exceeding 25,000 rupees to the person affected by such contravention or a penalty not exceeding 25,000 rupees. Section 46. Power to adjudicate. For the purpose of adjudging under this chapter whether any person has committed a contravention of any of the provisions of this Act or of any rules, regulations, direction or order made under there which makes him liable to pay penalty or compensation, the central government shall subject to the provisions of subsection 3 appoint any officer not below the rank of a director to the Government of India or any equivalent officer of a state government to be an adjudicating officer for holding an inquiry in the manner prescribed by the central government. First, the adjudicating officer appointed under subsection 1 shall exercise jurisdiction to adjudicate matters in which the claim for injury or damage does not exceed rupees 5 crores, provided that the jurisdiction in respect of the claim for injury or damage exceeding rupees 5 crores shall vest with the competent court. Second, the adjudicating officer shall, after giving the person referred to in subsection 1 a reasonable opportunity for making representation in the matter, and if on such inquiry he is satisfied that the person has committed the contravention, he may impose such penalty or award such compensation as he thinks fit in accordance with the provisions of that section. Third, no person shall be appointed as an adjudicating officer unless he possesses such experience in the field of information technology and legal or judicial experience as may be prescribed by the central government. Fourth, where more than one adjudicating officers are appointed, the central government shall specify by order the matters and places with respect to which such officers shall exercise their jurisdiction. Fifth, every adjudicating officer shall have the powers of a civil court which are conferred on the cyber appellate tribunal under subsection 2 of section 58, and a. all proceedings before it shall be deemed to be judicial proceedings within the meaning of sections 193 and 228 of the Indian Penal Code. B. shall be deemed to be a civil court for the purposes of sections 345 and 346 of the Code of Criminal Procedure 1973. C. shall be deemed to be a civil court for purposes of orders XX1 of the Code of Civil Procedures 1908. 7. Factors to be taken into account by the adjudicating officer. While adjudging the quantum of compensation under this chapter, the adjudicating officer shall have due regard to the following factors, namely a. the amount of gain of unfair advantage, wherever quantifiable, made as a result of the default; b. the amount of loss caused to any person as a result of the default; c. the repetitive nature of the default.
Chapter number 11, Liability of Intermediaries. This is presented by Parnish, Dhiman. Introduction. The term intermediary has been defined in section 2 with respect of any particular electronic record to mean any person who on behalf of another person receives, store or transmit that record or provides any service with respect to that record. The definition includes the following: telecom service provider, internet service provider, network service provider, web hosting service provider, search engines, online payment sites, online auction sites, cyber cafe. In the field of electronic communication pertaining to electronic records, there are three main persons. They are originator, intermediary, and addressee. Relevant section before amendment in section 79 in year 2008, the intermediary was liable for any civil wrong as well for any offence. However, after 2008, a new section 67C was inserted which has fixed criminal liability of intermediary under section 67C. It is duty to preserve and retain such information as may be specified, first for such duration and in such manner and format as the central government may prescribe. In any intermediary, the provision of section 67C, he shall be criminally liable with all. As per section 79(2)(c), he or she shall be civil liable if he does not observe due diligence which discharge his duty under this act and observe and such other guidelines such as central government may prescribe in this behalf. At this stage, it would be in best interest to reproduce the amendment section 79 of Information Technology Act 2000, which read as follow. Sector 79, exemption from liability of intermediary in certain cases. Notwithstanding anything contained in any law of for the time being enforced but subject to provision of subsections 2 and 3, and intermediary shall not be liable for any third party information, data, or communication link made available or hosted by him. The provision of subsection shall apply if a function of intermediary is limited to providing access to a communication system over which information made available by third party is transmitted or temporarily stored or hosted, or the intermediary does not initiate the transmission, select the receiver of the transmission, and select or modify the information contained in the transmission. The intermediary deserves due diligence while discharging this duty under this act, and also observe such other guidance as the central government may prescribe in this behalf. The provision of subsection 1 shall not, if the intermediary has conspired or aided or induced with whether by threat or promise or otherwise in the commission of unlawful act, upon receiving actual knowledge begin notified by the appropriate government or its agency that any information, data, or communication link resides in or connected to a computer resources controlled by the intermediary is begin used to commit the unlawful act. The intermediary fails to recover or disable access to that material on that resource should violating the evidence in any matter. Explanation. For the purpose of this section, the expression third party information means any information dealt with by an intermediary is in his capacity as an intermediary. The present provision is now, after the amendment, more transparent as the liability of the intermediary has been clearly stated. Moreover, the Intermediary Rules 2011 has been drafted under Section 79. The intention behind the drafting of this rule was to assist the intermediary to avail exemption from liabilities for the services that are facilitated by them. Especially due to the famous case of base.com, there was a lot of demand for more clarity of the rules pertaining to exemption of intermediaries. The rational section behind Section 79 of the IT Act is to provide a form of sub-harbor protection for intermediary from liability from the action of its user. No doubt, they has to observe certain due diligence and also has to act on receiving notice that its services are being used to facilitate an illegal act. Tata Sons Limited versus Greenpeace International and ANR. Tata Sons Limited versus Greenpeace International and ANR. The court has refused to interim injunction for the Tatas to block the Tata versus Turtle game. The court granting an injunction would freeze the entire public debate on the effect of the port projection on the olive-riddled turtle's habitat. It is relevant to mention that Tata Sons Limited has claimed a decree for permanent injunction and damage to the extent of rupees 10 crore against defendants for using the plaintiff's trademark Tata without the permission of plaintiff, hereby the infringing its trademark rights. However, with the rule coming into place, person may now directly file complaint with private intermediaries. The interest of them is to maintain risk losing their protection. Intermediaries and liability for user-generated content. The best illusion for the liabilities of intermediaries is the case of Avnish Bajaj versus State, Bees.com case, in which Avnish Bajaj, the CEO of Bees.com, an auction portal, was arrested for an obscene MMS clip which was put up for sale on the site by the user. Although the judge of Honorable Delhi High Court did not consider Section 79 of the IT Act and focused on the provisions of the Indian Penal Code, the content can be related to the concept of liabilities of intermediaries. Brief fact of the case: a video clip dispatching two children of school in Delhi engaging in sexual act has offered for sale on the website of Bees.com, a wholly owned subsidiary of eBay USA. To be a seller or a buyer, a person has to first register with Bees.com. The video clip has offered for sale on the website said by student of IIT Khagarpur under the subhead or subcategory of ebooks. 8 copies of MMS clip were sold, and due to alert information, the matter was reported and the item on the website was closed on the date. Busy.com wrote to a concerned person that the listing was obscene or pornography in the nature and that the Busy offer agreement prohibition trade in such item. The IT student was tracked down and arrested. The charges were filed against the student, managing director of Busy.com Avinash Bajaj, and the senior manager, trust and safety of Busy.com. Various condemnations were taken by Avinash Bajaj as he was charged under Section 292, Section 294 of the IPS and Section 64 of IT Act. The Honorable Delhi High Court was of the view that the object being offered for sale was obscene by not having appropriate filter that could have detected the words in the listing or the pornographic content on which has been offered for sale. The website ran the risk of the presumption that it had the knowledge that such object was in fact obscene. The court concluded that as far as the company was concerned, the offence being the listed of the video clip for sale attracted Section 292 of the IPS. The court also found that although Busy.com claimed that the filter existed to block objectionable material, investigation revealed that the claim made by company were only an eyewash. Therefore, according to the court, the company has ignored established industry norms to prevent offence content from being published online. Judgment of the Delhi High Court. At the junction, it would be irrelevant to brief the following summary of conclusion were made mention by Honorable Court. They are follow. First, the charge sheet when read as a whole bring out a prima facie case attracting the offence sections 292(1)(a), 292(2)(d of the IPC and section 67 of the IT Act. However, not even a prima case of the offence under section 294 of the IPC was found to be made. The prima facie case of the offence under section 292 and 292(2)(a) and 292(2)(d of the IPC was held to be made out against Busy.com Private Limited (BIPL) was named as eBay India Private Limited, both in respect of the listing the video clip respectively. However, as far as the Avinash Bajaj was concerned, since the IPC doesn't recognize the concept of an automatic criminal liability attaching to the director, where the company is an accused, not even a prima facie case of the offence under section 292 of IPS was made out, even when the charge sheet is read as a whole. It only seeks to implicate him in the designation of MD of BIPL and not in the individual capacity. Therefore, the petition was ordered to be discharged as far as offence under 292, section 292 and 294 of the IPS were concerned. While the case against the petition for the offence under section 292 and 24 of the IPC was cautioned, the prosecution of the petition of the offence under section 67 read with section 85 of the IT was ordered to be continued. The duty of intermediary under the Act. Under the section 67C of the Act, the intermediary shall preserve the retain such information as may be specified for such duration and in such manner and format as the central government may prescribe. Under section 69 of the Act relating to power to issue direction of interception or monitoring any information through any computer resources, the subscriber or any person in charge of the computer resource shall, when called upon by any agency referred to the subsection extend all facility and technical assistance to provide access to or secure access to the computer resource generating, transmitting, receiving, or storing sub information, or intercept, monitoring, as the case may be, or provide information stored in a computer resources. Third, under section 69A of the Act relating to blocking public access of any information through any computer resource, the intermediary has to compile and with the direction used by the government in this regards. Under section 69B of the Act relating to monitoring the collecting traffic data or information through any computer resources of cybersecurity, the intermediary or any person in charge of the computer resources shall, when called upon by the agency's authorities, provide technical assistance and extend all facilities to such agencies to enable online access or secure any provide online access of computer resources generating, transmitting, receiving, or storing such traffic data or information. Conclusion. Therefore, the amended section 79 provide an exemption for liability of the internet service provider ISP, which function as a passive service provider or transmitting information, and not as a person who create or modify the content. In order to avail to the exemption, the intermediary must observe due diligence and also observe other guidelines which the central government may prescribe. Therefore, an intermediary can avail of a safe harbor as per section 79, provided that it does not act as a content provider. The rule resulted in placing the ons of the intermediaries to restrict the content posting on the internet, as they run the risk of losing their safe harbor protection. In the content of is not removed or receiving a complaint, they will earn on the side of a caution, and it will result to removal of the perfectly legal content.
Chapter number 12, Offenses. Try not to become a man of success, but rather try to become a man of value, said by Albert Einstein. So the introduction. Chapter 11 of the Information Technology Act deals with diverse forms of cybercrime. Even though developments in cyber technology are beneficial in a variety of ways, the advent of new technology has given rise to various forms of cyber crimes. The terms computer crime, computer-related crime, high-tech crime, cyber crime, etc. are often interchanged with one another and have similar meanings. Chapter 11 of the IT Act contains penal prohibitions for the commission of cyber crimes. This chapter has substantially increased its horizons after the IT Amendment Act 2008. The amendments have added several new provisions which have carved new categories of cybercrime. The cybercrimes range across a huge spectrum and are distinct from the traditional crimes. Offenses listed under the IT Act. It would be relevant to mention various types of cyber offenses which have been expressly mentioned in the IT Acts, as well as the changes, amendments, additions in the Indian Penal Code, which can make an accused guilty under its provisions. The IT Act has dealt with the following crimes under Chapter 11. First, section of the IT Act 65. Nature of cyber offense was tampering with computer source documents. Under 66 Act, dishonesty or fraudulently doing any computer-related offense. Under 66A, sending offensive messages through communication service, etc. Under 66B, dishonestly receiving stolen computer resource or communication device. Under 66C, identify theft. Under 66D, cheating by personation by using computer resource. Under 66E, violation of privacy. Under 66F, cyber terrorism. Under 67, publishing of information in electronic form which is lascivious or appeals to the prurient interest. Under 67A, publishing or transmitting of material containing sexually explicit act, etc. in electronic form. Under 67B, publishing or transmitting of material depicting children in sexually explicit act, etc. in electronic form. Under 67C, preservation and retention of information by intermediaries. Under 68.2, intentionally or knowingly fails to comply with any order of the controller. Under 69, when any subscriber or intermediary fails to intercept or monitor or decrypt any information through any computer resource. Under 69A, when the intermediary fails to block for public access any information through any computer resource after directions have been issued. Under 69B, when the intermediary fails to monitor and collect traffic data or information through any computer resource for cybersecurity. Under 70, secures access or attempts to secure access to a protected system. Under 71, misrepresentation or suppression of any material. Under 72, breach of confidentiality and privacy. Under 72A, disclosure of information and breach of lawful contract. Under 73, publishing electronic signature certificate false in certain particulars. Under 74, publication of electronic signature certificate for fraudulent or unlawful purpose. Under 75, offense or contravention of the act committed outside India. Under 76, confiscation. Offences listed under the Indian Penal Code. Following offences under the Indian Penal Code will be tried as per the provisions of the Code of Criminal Procedure. These offences are triable either in the judicial magistrate of the first class or by the Court of Sessions. So the first section of the IPC under 167. Nature of cyber offence was public servant framing an incorrect electronic record with intent to cause injury. Under 172, absconding to avoid service of summons to produce electronic record. Under 173, preventing service of summons or preventing publication of summons. Under 175, intentional omission to produce electronic record triable in the court that issued the summons or order to produce the document. In other cases, it is triable by any magistrate. Under 192, fabricating false electronic evidence. If committed for using evidence before a judicial proceeding, then it is triable by a judicial magistrate of first class. Otherwise, any magistrate can try it. Under 204, destroying of electronic record to prevent its production as evidence. Under 463, forgery. 464, making a false document or electronic record. 466, forgery of record of court or of public register, etc. 468, forgery for the purpose of cheating. 469, forgery for the purpose of harming reputation. 471, using as genuine a forged document or electronic record. 474, knowingly possessing a forged document. 476, counterfeiting device or mark used for authenticating document, electronic record. 477A. Falsification of accounts. The above mentioned table reflecting various offences as well as their nature would be helpful as a ready reference to locate the type of cybercrime. Hacking. The basis of Section 66 pertaining to computer-related offences is Section 43. Section 66 reads as follows. Computer-related offences. If any person dishonestly or fraudulently does any act referred to in Section 43, he shall be punishable with imprisonment for a term which may extend to 3 years or with fine which may extend to 5 lakh rupees or with both. Therefore, the above mentioned section makes it clear that if there is no dishonest or fraudulent act, it will amount to a civil wrong under Section 43. If the act of any person is accompanied with dishonest or fraudulent intention, then it can be covered under Section 66 and he shall be punishable with imprisonment for a term which may extend to 3 years or with fine which may extend to 5 lakh rupees or with both. Though the IT Amendment Act 2008 has completely substituted Section 66 and has magnified its scope from mere prohibiting hacking to any act referred to in Section 43. If committed dishonestly or fraudulently, the provisions still essentially work to prohibit hacking. Hacking causes wrongful loss or damage to the computer, diminishes the value of the computer resource, and affects the computer resource injuriously. Hence, hacking is an attempt to exploit a computer service or a private network inside a computer. Simply put, it is unauthorized access to or control over computer network security system for some illicit purpose. Computer hacking includes Part A. Hacker culture. It implies a culture of individuals who enjoy the intellectual challenge of creativity, overcoming the limitations of software. Any act by individuals which is done in a spirit of playfulness and exploration is termed as hacking. Such hackers try to distinguish themselves as having no malignant or malevolent purposes. Part B. Security hacker. A security hacker is an individual who seeks to breach defenses and exploits weakness in a computer system or network. He may be motivated by a number of reasons such as profit, money making, information gathering to evaluate weaknesses so as to form a better defense, etc. Part C. Phone hacking. Phone hacking is the practice of manipulating or gaining unauthorized access to mobile phones, such as by intercepting telephone calls, voice calls, etc. This term came into vogue after the news of an international phone hacking scandal wherein employees of a British newspaper were accused of engaging in phone hacking and exercising improper influence in the pursuit of their stories. The Prime Minister, David Cameron, announced on 6th of July 2011 that a public inquiry known as Levison Inquiry would look into phone hacking in this case. A number of arrests and conviction followed, most notably of the former News of the World managing editor Andy Coulson. Computer viruses. The wording of Section 66 clearly refers to Section 43 of the Act and therefore includes within its ambit, destroys or deletes or alters any information residing in a computer resource or diminishes its value or utility. I repeat, it destroys or deletes or alters any information residing in a computer resource or diminishes its value or utility. There are various manners through which the utility can be diminished. One such way is committing hacking by means of sending the virus to the computer resource. Now, what is a virus? A computer virus is a type of malicious software program that, when executed, replicates itself by modifying other computer program and inserting its own code. It causes damage to the computer system. A vast majority of virus target system running the operating system Microsoft Windows and often use complex high-ended technology to escape antivirus software. Virus is a major threat to cybersecurity and causes whopping financial losses due to system failure, wasting computer resources, corrupting data, etc. The term computer virus was coined by Frederick P. Cohen in 1985. He is an American computer scientist and best known as the inventor of computer virus defense techniques. The term virus also includes within its ambit other types of malware such as Part A. Computer worms. It is a program in a network of computers using bugs or passwords to gain access to computers. It is a standalone malware computer program and often uses a computer network to spread itself. There have been two major outbreaks of worms on the internet, that is Morris worm, which was one of the first computer worms distributed via the internet. It is estimated that around 6,000 major Unix machines were infected by the Morris worm. Robert Tappan Morris was tried and convicted of violating United States Code, Title 18, and he was sentenced to 3 years probation, 400 years of community service, and a fine of $10,050 plus the costs of his supervision. The other famous computer worm is MyDoom, which affected Microsoft Windows. It became the fastest spreading email worm, exceeding previous records set by any other worm. It was primarily transmitted via email, and the email contained an attachment that, if executed, resends the worm to the email addresses found in local files such as user's address book. Another notorious computer worm that attacked tens of millions of computers is referred to as a love bug. It started to spread as an email message with subject line as I love you. There was a hidden attachment, and the said worm damaged the local machine, overwriting random types of files. It combined sophisticated programming. As per figures published on 8th of May 2000 by Trend Micro Inc., I Love You had infected 3.1 million computers worldwide. It originated in the neighborhood of Manila on May 5, 2000. In the year 2002, the I Love You virus obtained a world record for being the most virulent computer virus at that time. Part B. Trojan horses. It is another kind of program which is malicious and used for hacking. Trojans may allow an attacker to access users' personal information such as banking information, passwords, or personal identity. They can lead to crashing the computer, modification, or deletion of files. I repeat, they can lead to crashing the computer, modification, or deletion of files. This virus is not common and is found generally on computer bulletin boards. Trojan horses may require interaction with a malicious controller to fulfill their purpose. One of the examples of a Trojan horse malware is Zeus, which runs on a version of Microsoft Windows and can be used to carry out many malicious and criminal tasks. In June 2009, the security company Previx discovered that Zeus has compromised over 74,000 file transfer protocol accounts on websites of companies such as Bank of America, NASA, Amazon, Monster.com, ABC, Oracle, Play.com, Cisco, and Businessweek. Part C. Keyloggers. It is the action of recording the keys struck on a keyboard so that the person using the keyboard is unaware that their actions are being monitored. It can be a software-based keylogger or hardware-based keylogger. Now the conclusion of the chapter. Hence, hacking as a cybercrime is one of the most dangerous crimes of the internet because it has the potential to erode the very credibility of the internet. Hacking also makes e-commerce difficult and dangerous. Effective efforts need to be made to combat this phenomenon of hacking, as various cases have been reported in India, receiving prominence because of the manner of hacking. There have been a number of Indian websites which have been hacked and defaced, resulting in various corresponding issues. Hence, one of the other connected attributes is to adequately train the investigating agency in the field of cybercrime so that the investigating agency is sufficiently equipped to use the existing provisions in a comprehensive manner to fight cybercrime.
Chapter number 13 to 20.
Chapter number 13. Section 66A. People demand freedom of speech as a compensation for the freedom of thought which they seldom use. By Søren Kierkegaard. Introduction. It is adrem to mention that Section 66A of the IT Act has been declared unconstitutional by the Honorable Supreme Court being the violative of the freedom of speech and expression under Article 19A of the Constitution of India. It would, however, be useful to reproduce the said section, which earlier read as follows. So Section 66A was read as follows. Punishment for sending offensive messages through communication services, etc. So what does it mean? Any person who sends by means of a computer resource or a communication device, Part A, any information that is grossly offensive or has menacing character, or Part B, any information which he knows to be false but for the purpose of causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal, intimidation, enmity, hatred, or ill will persistently by making use of such computer resource or a communication device. Or Part C, any electronic mail or electronic mail message for the purpose of causing annoyance or inconvenience, or to deceive or to mislead the address or recipient about the origin of such message, shall be punishable with imprisonment for a term which may extend to 3 years and with fine. So the explanation of this act. For the purpose of this section, terms electronic mail and electronic mail message means a message or information created, transmitted, or received on a computer, computer system, computer resource, or communication device, including attachments in text, image, audio, video, and any other electronic record which may be transmitted with the message. Now, Shreya Singhal versus Union of India. The section punished for sending offensive messages by means of a computer resource or a communication device and indicated 3 broad categories within its ambit. However, on 24th March 2015, the Honorable Supreme Court in the case of Shreya Singhal versus Union of India
upholding the right of free speech and expression in this landmark judgment, has declared Section 66A to be unconstitutional. This section dealt with information disseminated over the internet, and the IT Act does not prescribe any specific guidelines to determine if the information falls in any of the offensive categories mentioned under Section 66A. In the present landmark judgment, it was contended inter alia on behalf of petitioner that there were various issues with regard to unconstitutionality of Section 66A, such as it directly infringing the fundamental right of free speech and expression, as well as suffering vice of vagueness. It was also contended that various innocent persons are roped in under this section, and it is open to the authorities to be arbitrary and whimsical as they like booking such persons under the said action. On varied grounds, the Honorable Supreme Court, by applying various tests, held Section 66A to be unconstitutional in nature. Wherefore, comments on social networking sites will not be considered to be offensive until and unless they come under the provisions of the Indian Penal Code. So, coming on chapter number 14, Section 66B. I care not what others think of what I do, but I care very much about what I think of what I do. That is character. Said by Theodore Roosevelt. So, under Section 66B, punishment for dishonestly receiving stolen computer resources or communication device. So what does it mean basically? Whoever dishonestly receives or retains any stolen computer resource or communication device, knowingly or having reason to believe the same to be stolen, computer resource or communication device, shall be punished with imprisonment of either description for a term which may extend to 3 years, or with fine which may extend to rupees 1 lakh, or with both. Section 66B deals with the following two types of offences. First, dishonestly receiving or retaining any stolen computer resource or communication device. Second, knowing or having reason to believe the same to be stolen computer resource or communication device. It is apposite to mention that the term dishonestly used in the present section has been defined under the Indian Penal Code by virtue of Section 24, which reads as follows. Whoever does anything with the intention of causing wrongful gain to one person or wrongful loss to another person is said to do that thing dishonestly. The term wrongful gain and wrongful loss have also been defined in the Indian Penal Code by virtue of Section 23, which reads as follows. Wrongful gain is gain by unlawful means of property, which the person gaining is not legally entitled. Wrongful loss is the loss by unlawful means of property to which the person losing it is legally entitled. Gaining wrongfully, losing wrongfully. What does it mean? A person is said to gain wrongfully when such person retains wrongfully, as well as when such person acquires wrongfully. A person is said to lose wrongfully when such person is wrongfully kept out of any property, as well as when such person is wrongfully deprived of property. This section has been inserted by the IT Amendment Act 2008, and there is a difference between Section 66 and Section 66B, as the offence under Section 66 is more serious than the offence under Section 66B. Now coming to chapter number 15, Section 66C. Like other forms of stealing, identity theft leaves the victim poor and feeling terribly violated. Said by George W. Bush. Now, identity theft under Section 66C. Punishment for identity theft. Whoever fraudulently or dishonestly makes use of electronic signature, password, or any other unique identification feature of any other person shall be punished with imprisonment of either description for a term which may extend to 3 years, and shall also be liable to fine which may extend to rupees 1 lakh. The ingredients of the offence are: Part A, a person fraudulently or dishonestly; Part B, makes use of; Part C, an electronic signature, password, or any other unique identification feature; Part D, of another person. The present section prescribes the penalty for identity theft, that is, when a person uses the electronic signature, password, or unique identification feature of any other person dishonestly or fraudulently, he is said to have committed offense of identity theft. Identity theft is also known as identity fraud, and any information so obtained can be used for credit and other services. In the name of the victim. In rare cases, an impostor may provide false identification to the police, creating a criminal record, etc. There can be various different examples of identity theft, such as: first, tax-related identity theft; second, medical identity theft; third, child identity theft; fourth, senior identity theft; fifth, financial identity theft. So under Section 66D, what a computer is to me is the most remarkable tool that we have ever come up with. It is the equivalent of a bicycle of our minds, said by Steve Jobs. Now, cheating by impersonation. Under Section 66D, punishment for cheating by impersonation by using computer. So what does it mean? Whoever by means of any communication device or computer resource cheats by impersonation shall be punished with imprisonment or of either description for a term which may extend to 3 years, and shall also be liable to fine which may extend to 1 lakh rupees. The present section has also been inserted by the IT Amendment Act 2008 with the aim to provide a deterrent against the increasing cases of cheating by impersonating. This crime is also referred to as phishing, which is one of the most dangerous crime causing various financial losses. The following are the ingredients of the present offense. First, a person by means of a communication device or computer resource. Second, cheats another by impersonation. Now, with the insertion of this section, phishing, in addition to being a civil wrong, has also become a penal offense. Before the insertion of this provision, there have been varied instances when parties have only sought civil compensation. However, the present section now provides the punishment for a term of imprisonment which may extend to 3 years, and with a fine which may extend to rupees 1 lakh. Now coming to chapter 17, under section 66E. Civilization is the progress towards a society of privacy, by Ayn Rand. Electronic voyeurism, under section 66E. Punishment for violation of privacy. Whoever intentionally or knowingly captures, publishes, transmits the image of a private area of any person without his or her consent under circumstances violating the privacy of that person shall be punished with imprisonment which may extend to 3 years, or with fine not exceeding 2 lakh rupees, or with both. What's the explanation for this? For the purposes of this section, first, Transmit means to electronically send a visual image with the intent that it be viewed by a person or person. Second, capture with respect to an image means to videotape, photograph, film, or record by any means. Third, private area means the naked or undergarment clad genitals, pubic area, buttocks, or female breast. Fourth, publishes means reproduction in the printed or electronic form and making it available for public. Fifth, under circumstances violating privacy means circumstances in which a person can have a reasonable expectation that he or she could disrobe in privacy without being concerned that an image of private area was being captured. Or second part, any part of his or her private area would not be visible to the public regardless of whether that person is in a public or private place. The present section is a pivotal provision as it seeks to prohibit electronic voyeurism. The ingredients for the commission of an offense of violation of privacy are as follows. First, a person intentionally or knowingly. Second, capturing, publishing, or transmitting. Third, the image of a private area of another person. Fourth, without consent. Fifth, under circumstances violating privacy. The right to privacy is a legal concept in both law of torts and the constitutional law, subject to limitations of public policy. The violation of privacy through electronic images has now been declared as an offense, and with the explosion of electronic devices, new forms of hidden cameras, etc., there was a growing concern of having for such a provision to curb the trend of electronic voyeurism. The present section provides for punishment which may extend to 3 years or with fine not exceeding 2 lakh rupees or with both. Now coming to chapter 18, Cyber Terrorism and Combat Mechanism. I think computer viruses should count as life. I think it says something about human nature that the only form of life we have created so far is purely destructive. This is said by Stephen Hawking. Now under section 66F, punishment for cyber terrorism. Whoever with intent to threaten the unity, integrity, security, or sovereignty of India or to strike terror in the people or any other section of the people by denying or cause the denial of access to any person authorized to access computer resource or attempting to penetrate or access a computer resource without authorization or exceeding authorized access, or introducing or causing to introduce any computer contaminant and by means of such conduct causes or is likely to cause death or injuries to persons or damage to or destruction of property or disrupts or knowing that it is likely to cause damage or disruption of the supplies or services essential to the life of the community or adversely affect the critical information infrastructure specified under section 70 or knowingly or intentionally penetrates or accesses a computer resource without authorization exceeding authorized access and by means of such conduct obtains access to information, data, or computer database that is restricted of reasons for the security of the state or foreign relations or any restricted information, data, or computer database with reasons to believe that such information, data, or computer database so obtained may be used to cause or likely to cause injury to the interests of the sovereignty and integrity of India, the security of the state, friendly relations with the foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offense, or to the advantage of any foreign nation, group of individuals, or otherwise. Cyber terrorism denotes unlawful attacks and threats of attack against computer, network, and information stored therein to intimidate or coerce a government of its people for propagating any wrongful agendas. This section carves a specific provision dealing with cyber terrorism. It would be helpful to lay out certain characteristics of cyber terrorism. They are as follows. First, attack is predefined and victims are specifically targeted. Second, attack has an objective to destroy or damage specific targets such as political, economic, energy, civil, and military infrastructure. Attack may even target specific opposing religious groups, information infrastructures to incite religious racket. Fourth, the purpose of any attack is to create fear of the group's intentions and further their own political agenda or goals or gain fellowship by succeeding in their attacks. Destroy enemies' capabilities to further operate within their own arena. So, I was continuing with the characteristics of cyber terrorism. The fifth one was destroy enemies' capabilities to further operate within their own arena. Sixth, persuade others to believe that the victim or victims are vulnerable and their stability is negligent. Seventh, create increased loyalty and pride within the group based on their successes. So why is cyber terrorism becoming a popular choice for terrorists? So answer for this have 4 points. First, it is more economical than any other traditional method of terrorism. They just need a personal computer and an online connection to create all kinds of mayhem. Second, cyber terrorism is anonymous to a far greater extent than normal terrorism. Here, terrorists use some kind of nicknames or may log on to a website as an unspecified guest user. Third, the multiplicity of targets the cyber terrorist could aim the computers and computer networks of governments, individuals, public utilities, etc. This kind of terrorism does not need any kind of physical training, psychological investment, and no risk of morality is faced by them, etc. Now, instances of cyber terrorism. First, in 1996, a computer hacker illegally associated with the white supremacist movement temporarily disabled a Massachusetts ISP and damaged part of the ISP's record-keeping system. The ISP had attempted to stop the hacker from sending out worldwide racist messages under the ISP's name. The hacker signed off with the threat, "You have yet to see true electronic terrorism. This is a promise." So this was the threat of the hacker. Now the second instance. In 1998, Spanish protesters bombarded the Institute for Global Communications, IGC, with thousands of bogus email messages. The email was tied up and undeliverable to the ISP's users, and support lines were tied up with people who could not get their mail. The protesters also spammed the IGC staff and member accounts, clogged their web pages with bogus credit card orders, and threatened to employ the same tactics against organizations using IGC services. They demanded that IGC stop hosting the website for the Yusko Heria Journal, a New York based publication supporting Basque independence. Protesters said IGC supported terrorism because a section on the web pages contained materials on the terrorist group ETA, which claimed responsibility for assassinations of Spanish political and security officials and attacks on military installations. IGC finally relented and pulled the site because of the mail bombings. Third instance, in 1998, ethnic Tamil guerrillas attempted to disrupt Sri Lankan embassies by sending large volumes of email. The embassies received 800 emails a day over a 2-week period. The message read, "We are the Internet Black Tigers, and we are doing this to disrupt your communications." The fourth instance, during the Kosovo conflict in 1999, NATO computers were blasted with email bombs and hit with denial of service attacks by hacktivists protesting the NATO bombings. Since December 1997, the Electronic Disturbance Theatre EDT has been conducting web sit-ins against various sites in support of the Mexican Zapatistas. At a designated time, thousands of protesters point their browsers to a target site using software that floods the target with rapid and repeated download requests. In the year 2000, Japanese investigation revealed that the government was using software developed by computer companies affiliated with Shinrikyo, the Doomsday sect responsible for the sarin gas attack on the Tokyo subway system in 1995. The government found 100 types of software programs used by at least 10 Japanese government agencies, including the Defense Ministry and more than 80 major Japanese companies, including Nippon Telegraph and Telephone. Following the discovery, the Japanese government suspended use of ARM-developed programs out of concern that ARM-related companies may have compromised security by breaching firewalls, gaining access to sensitive systems or information, allowing invasion by outsiders, planting viruses that could be set off later, or planting malicious code that could cripple computer systems and key data systems. The seventh instance. In March 2013, the New York Times reported on a pattern of cyber attacks against US financial institutions believed to be instigated by Iran, as well as incidents affecting South Korean financial institutions that originate with the North Korean government. In August 2013, media companies including the New York Times, Twitter, and the Huffington Post lost control of some of their websites after hackers supporting the Syrian government breached the Australian internet company that manages many major site addresses. Ninth instance. Pakistani Cyber Army is the name taken by a group of hackers who are known for their defacement of websites, particularly Indian, Chinese, and Israeli companies that governmental organizations claiming to represent Pakistani nationalist and Islamic interests. The group is thought to have been active since at least 2008 and maintains an active presence on social media. Website defacement. In October 2007, the website of Ukrainian President Viktor Yushchenko was attacked by hackers. A radical Russian nationalist youth group, the Eurasian Youth Movement, claimed responsibility. So, the conclusion for this chapter: hence, cyber terrorism is a radical threat to the world at large. The internet is the largest single component of cyberspace with a presence in more than 200 countries. We need to ask certain questions to ourselves. Is there adequate awareness of cyberspace, cybercrimes, and cyber laws? How do we try to deal with terrorism in cyberspace? On this aspect, the answer lies in education, awareness, and preparation. We need to be prepared. Various crime cells, investigating agencies need to be trained adequately to deal with such crimes. From email-related crimes to frauds, the crime of cyber terrorism is assuming extreme complications. We need to combat this threat through a three-pronged strategy, that is, prevention, incident management, and consequence management. I am reminded of a couplet by Moin Ehsan Jazbi. जब कश्ती साबित और सलीम थी, साहिल की तमन्ना किसको थी? अब ऐसी शिकास्ता कश्ती पर साहिल की तमन्ना कौन करे? This couplet certain provides the stimulus to all of us to better take concrete steps before it gets too late. The only solution lies in the transformation into cyber Czars. Now, chapter number 19. Cyber Pornography and IT Act. Technological progress is like an axe in the hands of a pathological criminal, by Albert Einstein. So, the introduction. The word porn stands for prostitute and graphene stands for documentary. Pornography literally means documenting a prostitute or depictions of acts of prostitutes. Pornography in the eyes of law is not necessarily obscene. There are millions of individually owned pornography websites. Research shows that 50% of the websites containing potentially illegal contents related to child abuse were pay per view. This indicates that abusive images of children over the internet have been highly commercialized. As per the Oxford Dictionary, pornography has been defined as the explicit description or exhibition of sexual subjects or activity in literature, painting, films, etc., in a manner intended to stimulate erotic rather than aesthetic feelings.
This is recording by Tanisha Garg. Continuing from page number 153, it would be helpful to lay out certain characteristics of cyber terrorism. They are as follows. First, attack is predefined and victims are specially targeted. Second, attack has an objective to destroy or damage specific targets such as political, economic, energy, civil and military infrastructure. Third, attack may not even target specific opposing religions, groups, information and infrastructures to incite religious racket. Fourth, the purpose of any attack is to create fear of the group's intentions and further their own political agenda or goals or gain fellowship by succeeding in their attacks. Fifth, destroy enemies' capabilities to further operate within their own arena. Sixth, persuade others to believe that the victim or victims are vulnerable and their stability is negligent. Page number 154. Seventh point, create increased loyalty and pride within the group based on their successes. Question: Why is cyber terrorism becoming a popular choice for terrorists? First, it is more economical than any other traditional method of terrorism. They just need a personal computer and an online connection to create any kinds of mayhem. Second, cyber terrorism is anonymous to a far greater extent than normal terrorism. Here, terrorists use some kind of nicknames or may log on to a website as an unspecified guest user. Third, the multiplicity of targets. The cyber terrorists could aim the computers and computer networks of governments, individuals, public utilities, etc. Fourth, this kind of terrorism does not need any kind of physical training, psychological investment, and no risk of mortality is faced by them, etc. 155 page instances of cyber terrorism. First, in 1996, a computer hacker allegedly associated with the white supremacist movement temporarily disabled a MASSA CHUSETTS ISP and damaged part of the ISP's records keeping system. The ISP had attempted to stop the hacker from sending out worldwide racist messages under the ISP's name. The ISP had attempted to stop the hacker from sending out worldwide racist message under the ISP's name. The hacker signed off with the threat, inverted comma starts, "You have yet to see the true electronic terrorism. This is a promise," close. Second point, in 1998, a Spanish protesters bombarded the Institute of Global Communications, bracket starts, IGC, bracket close, with thousands of bogus emails, messages, full stop. The email was tied up and undeliverable to the ISP's users, and support lines were tied up with the people who could not get their email. Full stop. The protesters also spammed the IGC staff and members' accounts, clawed their web pages with the bogus credit orders, and threatened to employ the same tactics against the organizations using IGC services. They demanded that IGC stop hosting the website for the Esquilheria Journal, a New York-based publication supporting basic independence. Protesters said IGC supported terrorism because a section on the web pages contained minerals on the terrorist group ETA, which claimed responsibility for assassinations of Spanish political and security officials and attack on military. Page number 156. Installations. IGC finally relented and pulled the site off because of the mail bombings. Third point. In 1998, ethnic Tamil guerrillas attempted to disrupt Sri Lankan embassies by sending large volumes of ML. The embassies received 800 emails a day over a 2-week period. The message read, "We are the internet black tigers and we are going to do this disrupt your communications." Fourth point. During the Kosovo conflict in 1999, NATO computers were blasted with the email bombs and hit with denial of service attacks by hacktivists protesting the NATO bombs. Fifth point. Since December 1987, the Electronic Disturbance Theatre bracket starts EDT has been conducting web sit-ins against various sites in support of the Mexican Zapatists, that is MEXICAN ZAPATISTAS. At a designated time, thousands of protesters point their browsers to target site using software that floods the target with a rapid and repeated download requests. 6. In the year 2000, a Japanese investigation revealed that a government using software developed by computer companies affiliated with AUMSHINRIKYO, the Doomsday sect responsible for the sarin gas attack in the Tokyo subway system in 1995. First up, the government found 100 types of software programs used by at least 10 Japanese government agencies, including the Defense Ministry and more than 80 major Japanese companies, including Nippon Telegraph and Telephone. Following the discovery, the Japanese government suspended use of developed programs out of concern that related companies may have compromised security by breaching firewalls, gaining access to sensitive systems or information, allowing invasion by the outsiders, planting viruses that could be set off later, or planting malicious code that could cripple computer system and key data system. 7th point, page number 157. In March 2013, the New York Times reported on a pattern of cyber attacks against US financial institutions believed to be instigated by the Iran, as well as the incidents affecting South Korean financial institutions that originate with the North Korean government. 8th point, in August 2013, media companies including the New York Times, Twitter, and the Huffington Post lost control of some of the websites after hackers supporting the Syrian government breached the Australian internet company that manages many other site addresses. 9th point, Pakistani Cyber Army is a name taken by the group of the hackers who are known for the defacement of websites. Page number 158. Particularly Indian, Chinese and Israeli companies and governmental organizations, claiming to represent Pakistani nationalist and Islamic interests, the group is thought to have been active since at least 2008 and maintains an active presence on the social media. Website defacement. In October 2007, the website of Ukrainian President Viktor Yushchenko was attacked by the hackers. A radical Russian nationalist youth group, the Eurasian Youth Movement, claimed responsibility. Conclusion. Hence, cyber terrorism is a racial threat to the world at large. The internet is the largest single concept of cyberspace, with a presence in more than 200 countries. We need to ask certain questions to ourselves. First, is there adequate awareness of cyberspace, cyber crimes and cyber laws? Question mark. Second, how do we try to deal with the terrorism in the cyberspace? Question mark. On this aspect, the answer lies in the education, awareness and preparation. We need to be prepared. Sign of exclamation. Various cybercrime cells, investigating agencies need to be trained to adequately deal with such crimes. First up, from email-related crimes, page number 159, to frauds, the crimes of cyber terrorism is assuming extreme complications. First stop. We need to combat this threat through a three-pronged strategy, that is prevention, incident management, and consequence management. I am reminding of a couplet by Moin Ahsan Jazbi. Next line, starts. जब कश्ती साबित ओ सालिम थी, साहिल की तमन्ना किसको थी? अब ऐसी शिकास्ता कश्ती पर, साहिल की तमन्ना कौन करे? ... close. This couplet certainly provides a stimulus to all of us to better take concrete steps before it gets too late. Full stop. The only solution lies in the transformation in cyber Czars. Page number 161. Chapter 9. Cyber Pornography and its Act. Technological processes like an axe in the hands of the pathological criminal, it's said by the Albert Einstein. Now the introduction. The word porn stands for prostitute and graphian stands for documentary. Pornography literally means documenting a prostitute or depictions of act of the prostitutes. Pornography in the eyes of laws is not necessarily obscene. These are millions of individually owned pornographic websites. Research shows that 50% of the website containing potentially illegal contents relating to child abuse were pay per view. This indicates that abusive images of the children over the internet have been highly commercialized. As per the Oxford Dictionary, pornography has been defined as the explicit description or exhibition of the sexual subjects or activity in literature, painting, films, etc., in a manner intended to stimulate erotic rather than aesthetic feelings. Page number 162. The Merriam-Webster Dictionary defines pornography as: first, writing, pictures, etc. intended primarily to arouse sexual desire. Second, the production of such writings, pictures, etc. With the content headway in science and technology, the pornographic content on the internet has increased at exponential level in all facets and components. From visual porn sites to pornography chat rooms, the intent of porn on the internet has caused addiction, escalation, and aggregation. With the current headway in science and technology, the pornographic content on the internet has increased at the exponential levels in all the facets and components. From visual porn sites to pornographic chat rooms, the extent of porn on the internet has caused addiction, escalation, and aggregation. With regression. These days, a huge quantity of pornographic material can be reproduced adroitly and at a low cost on new media devices such as hard disk, floppy disk, and CDs. Cyber pornography plays an preponderant role in negative social sciences such as children abuse, violence against women, youth crime, etc. The sheer volume of traffic and the potential for anonymity has further resulted in the lack of control over such content. With the introduction of the Information Technology (Amendment) Act 2008, various provisions have been carved out to deal with this endangerment. Now, even the responsibility of the cyber caf owners have been escabrated. Under the present Act, transmitting or publishing pornographic material is illegal. Page number 163. The Constitution of India enables the citizens to enjoy freedom in the speech and expression. Full stop. The state has been empowered to legislate in order to reasonably curtail their freedom, as per Article 19, (start 2), The ways and means to control pornography amongst ever-increasing trends, is a major trepidation and a controversial topic. The careful reading of the provisions of various acts which deal with the pornography and obscenity can be inferred to restrain obscenity which is indecent and deleterious to public morality. Next topic, indecent representation of women. (starts Prohibition Act, 1986). The title of this act makes it presumptuous that the intention of the legislature is to prohibit indecent representation. Pornography which amounts to indecent representation is an offense. Now the point is to be determined is as to what may amount to indecent representation. Section 2C of the Indecent Representation of Women Prohibition Act, 1986 defines indecent representation of women as the depiction in any manner of the figure of a woman, her form or body, or any part thereof in such a way as to have the effect of being indecent, or derogatory to or denigrating women, or is likely to deprave, corrupt, or injure the public morality or morals. Page number 164. Indian Penal Code, 1860. The Indian Penal Code, wide section 292 defines the offence for sale, etc. of an obscene book, pamphlet, paper, writing, etc. The section reads as follows. Section 292, full stop, sale, etc., obscene books, etc. First point, for the purpose of subsection 2, a book, a pamphlet, a paper, a writing, a drawing, a painting, a representation, a figure, or any other subject, shall be deemed to be obscene if it is lascivious or appears to be pretended interest, or if its effect, or starts where it compromises two or more distinct items, the effect of any one of its items, is, if taken as a whole, such as to deprave and corrupt person, who are likely, having regard to all relevant circumstances, to read, see or hear the matter contained or embodied in it. Further, subsection (starts 2) provides for the penal consequences, full stop. It provides for the punishment on the first conviction with the imprisonment of either description for the term which may extend it to 1,000 rupees, and in the event of a second or subsequent conviction, with the imprisonment of either description for a term which may extend to 5 years, and also with fine which may extend to 5,000 rupees. Page number 165. Judicial pronouncements. The term obscene as used in this provision has been subject to various judicial interpretations. Topic is R.D. Yudeshi v. State of Maharashtra. And on the top there's a 22 whose meaning will be written at the end. The Honorable Supreme Court, held in R.D. Yudeshi v. State of Maharashtra, that what is obscene would always remain a question to be decided in each case. However, the Honorable Apex Court, it was the duty of the court to consider the alleged obscene matter by taking an overall view of the entire work. It was further held that an overall view of the obscene matter in the setting of the whole work would of course be necessary, but the obscene matter must be considered by itself and separately to find out whether it is so gross and obscenity is so decided that it is likely to deprave and corrupt those open minds are open to influence the thought and into those whose hands and the books are likely to fall. Next topic, C.K. Karodar v. State of Maharashtra. On the top there is 23. Further, in the case of C.K. Karodar v. State of Maharashtra, the Honorable Supreme Court held that the standards of obscenity would differ from country to country depending on the standards. Now 22 is AIR 1965 SC 881. 23 is Czars 1969 2 SCC 683. 687. Page number 166. Of morals of the contemporary society, what is considered as a piece of literature in the France may be obscene in England, and what is considered in both countries are not harmful to public order, and morals may be obscene in the country. It is further held that what we have to see is whether a class and not an isolated case into whose hands the book, article, or the story falls, suffer in the moral outlook or become depraved by reading it, or might have impure and lecherous thoughts aroused in the minds. The charge of obscenity must therefore be judged from this aspect. Next topic, Samaresh Bose v. Amal Mitra. In the case of Samaresh Bose v. Amal Mitra, the Honorable Supreme Court provided the following guidelines. First, in her opinion, in judging the question of obscenity, the judge in the first place should try to place himself in the position of the author, and from the viewpoint of the author, the judge should try to understand what is it and the author seeks to convey, and what the author conveys has any literally and artistic value. So on the top of this topic there was 24. I forgot to tell. So what it means is AIR 1986 SC 967. Page number 167. Second point, the judge should thereafter place himself in the position of the reader of every age group in whose hands a book is likely to fall, and should try to appreciate what kind of possible influence a book is likely to have on the minds of the readers. Full stop. Third point, the judge should thereafter apply his judicial mind dispassionately to decide whether the book in question can be said to be obscene within the meaning of the section by the objective assessment of the book as a whole, and also of the passenger's complaint of an obscene separately. Next topic, Pramila Kanpur, Doctor, v. Yashpal Bhoshin. On the top there is 25. The case of Pramila Kanpur, Dr, v. is Yashpal Bhoshin before the Honorable Delhi High Court involved a book that was titled Indian Call Girls. It was written by an experienced sociologist giving an abridged version of the original work. The life and the world of call girls in India. The court felt that there was nothing wrong if a sociologist made a research on the subject of the call girls in order to know the reasons as to why and how the young girls fall in this profession, and what society could do in order to eradicate or at least minimize the possibility of young budding girls in the profession. The portion marked by the magistrate as obscene was, the meaning of that 25 was 1989 CR capital L capital J 12341 bracket slash DEL bracket close full stop. Page number 168. A description of their encounters with unscrupulous males, including a description by some girls of the first experience with the sex, but by far the bulk of book dealt with the ways and means of running the profession and the methods of encountering them. Thus the book was within the scope of clause A of the first exception. Therefore, as per the provision of section 292 IPC, though the author or the publisher has a utilitarian object which is innocent, however, if a publication has a tendency to deprave and corrupt the minds of the people reading it, it is within the purview of this section. Full stop. Next topic, Information Technology Act, 1000. Section 67 of this act deals with the offence, bracket starts, penal in nature, bracket close, of publishing of information which is obscene in the electronic form. Full stop. It is based on section 292 of the IPC and is one of the most paramount monoveers against pornography. Full stop. The section reads as follows. Section 67. Punishment for publishing or transmitting obscene material in the electronic form. Whosoever publishes or transmits or causes to be published or transmitted in the electronic form any material which is lascivious or appeals to be prurient interest, or if its effect is such as to tend to deprave or corrupt persons, is 169, who is likely, having regard to all the relevant circumstances, to read, see or hear the matter contained or embodied in it, shall be punished on first conviction with imprisonment of either description for a term which may extend to 3 years, and with fine which may extend to 5 lakh rupees, and in the event of second or subsequent conviction with imprisonment of either description for a term which may extend to 5 years, and also with fine which may extend to 10 lakh rupees. First, an essential part of the section is publication or transmission of material in the electronic form. Before the offence can be said to be complete, the publishing or transmission of the material in the electronic form is essential. Full stop. If such material A is lascivious, or B appeals to prurient interest, or C its effect is such as to tend to deprave and corrupt persons, are likely, having regard to all relevant circumstances, to read, see or hear the matter contained or embodied in it. Page 170. What comprises obscenity in electronic form? Question mark. To understand what encompasses obscenity in the electronic form, let us analyze the relevant terms. First, any material in the context of the section would include video files, audio files, text files, image animations, etc. These may be stored as CDs, websites, computers, cell phones, etc. Second point, lascivious is something that tends to excite lust. Second, appeals to, in this context means arouses interest. Fourth, prurient interest is characterized by lustful thoughts. Fifth, effect means to produce or cause some change or event. Sixth, tend to deprave and corrupt. In the context of this section means to lead someone to be morally bad. Seventh, person refers to the natural person, brackets are such as men, women, children, bracket close, and not artificial objects such as companies, societies, etc. Bracket close. 8. Acts that are punishable in respect of obscenity. Page 171. Acts punishable is a topic. Paragraphs in it are: to understand the acts that are punishable in respect of obscenity in the electronic form, let us analyze the relevant terms. First, publishes means to make known to others. It is essential that at least one natural person, bracket starts, man, woman or child, bracket close, becomes aware or understands the information that is published. Full stops. Simply putting up a website that is never visited by any person does not amount to publishing. Second, transmits means to pass along, convey, or spread. It is not necessary that a transmitter actually understands the information being transmitted. Third, causes to be published means to bring about publishing of something. It is essential that the actual publishing must take place. Next paragraph, it would be also relevant to make a brief mention of the section 67A, which deals with the offense of publishing electronic material containing sexual explicit act. The said section reads as follows. Section 67A, punishment for publishing or transmitting of material containing sexually explicit act and in electronic form. Whoever publishes or transmits or causes to be published, page number 172, or transmitted in the electronic form any material which contains sexually explicit act or conduct shall be punished on first conviction with the imprisonment of either description for a term which may extend to 5 years and with fine which may extend to 10 lakh rupees, and in the event of second or subsequent conviction of with the imprisonment of either description for a term which may extend to 7 years and also with a fine which may extend to 10 lakh rupees. This section has been inserted by the IT Amendment Act, 2008, and it expressively prohibits the publication or transmission of the Pornographic Act. The essential ingredients for the offence under the section 67A are: first, publication of transmission, or second, causing to be published or transmitted; third, any electronic message; fourth, which contains sexually explicit act or conduct. The punishment which has been prescribed under section 67A is: first, on first conviction, imprisonment for a term which may extend for 5 years with a fine which may extend to 10 lakh rupees, and second, 173 page, on the second or subsequent conviction, imprisonment for a term which may extend to 7 years with a fine which may extend to 10 lakh rupees. Publishing cyber pornography, echoes or provision, section 67. Acts covered: publishing, causing to be published, and transmitting cyber pornography. Penalty: first offence, simple or rigorous imprisonment up to 5 years and fine up to rupees 1 lakh. Subsequent offence, simple or rigorous imprisonment up to 10 years and fine up to rupees 2 lakh. Relevant authority, Court of Session. Appeal lies to High Court, page number 174. Investigation authorities: first, Controller of Certifying Authorities, CCA; second, person authorized by CCA; third, police officer not below the rank of deputy superintendent. Points to mention in complaint: first, complainant details; second, suspect details; third, how and when the contravention was discovered and by whom; fourth, other relevant information. Next topic is child pornography. Children are the future of our country. Full stop. Additional endeavor through potent steps should be taken by all the stakeholders to protect the child who by reason of his childhood are innocent, gentle and weak. It is rightly said that a child is an uncut diamond, therefore, they have to be sheltered from predators and require special attention for protection for their human rights. Next page, that is page number 175. In this epoch of technological advancement, children are exposed to new heights of intellect and maturity. Full stop. At the same time, they are exposed to various negative elements. Full stop. Loneliness, working parents, child abuse, child trafficking, child pornography are on an increase. Full stop. Child pornography is a form of child abuse which is related to the contemporary digital age. Full stop. Any material that visually depicts sexual content below a specified age can be rated as child pornography. It is not only pedophiles who indulge in such hideous crimes, but the pornographic websites also host such form of child abuse where children are becoming victims of crimes. Such offences are rarely brought to the notice of the law of enforcement agencies because of fear put in the child's mind, the unease of the parents and lack of awareness. Full stop. Such crimes impair the moral and ethical development of the child. Full stop. Under the Act, that is IT Act, child pornography has been exclusively dealt with by the Section 67B. The said section reads as follows. Section 67B. Punishment for publishing or transmitting of material depicting children in sexually explicit act, etc. in the electronic form. Whoever first publishes or transmitted or causes to be published or transmitted material in any electronic form which depicts children engaged in sexually explicit act or conduct, or page number 176. Second, creates text or digital images, collects, seeks, browse, downloads, advertises, promotes, exchanges, or distributes material in any electronic form depicting children in absence or indecent or sexually explicit matter, or third, cultivates, entices, or induces children to online relationship. Second, creates text or digital images. Second, creates text or digital images, collects, seeks, browses, downloads, advertises, promotes, exchanges, or distributes material in any electronic form depicting children in absence or indecent or sexually explicit manner, or third, cultivates, entices, or induces children to online relationship with one or more children for an on sexually explicit act or in the matter that may offend a reasonable adult on the computer resource, or fourth, facilitates abusing children online, or fifth, records in any electronic form on assume abuse or data of others pertaining to sexually explicit act with children, shall be punished on first conviction with imprisonment of either description for a term which may extend to 5 years and with fine which may extend to 10 lakh rupees, and in the event of second or subsequent conviction with imprisonment of either description for a term which may extend to 7 years and also with fine which may extend to 10 lakh rupees, provided that provisions of section 67, section 67A in this section do not extend to any book, pamphlet, paper, writing, drawing, painting, representation, or figure in the electronic form. First, the publication of which is proved to be justified as being for the public good on the ground that such book, pamphlet, 177, paper, writing, drawing, painting, representation, learning, or other objects of general concern, or second, which is kept or used for bona fide heritage or religious purposes. Explanation: for the purposes of this section, children means a person who has not completed the age of 18 years. The essential ingredients of this offence are as follows. Firstly, when anyone publishes or transmits or causes to be published or transmitted material in any electronic form which depicts a sexually explicit act or conduct, secondly, when a person creates text or digital images, collects, seeks, browses, downloads, advertises, promotes, exchanges, or distributes material in any electronic form depicting children in absence or indecent or sexually explicit manner, thirdly, when someone cultivates, entices, or induces children to online relationship with one or more children for an on sexually explicit act or in the matter that may offend a reasonable adult on the computer resource. Fourthly, when any person facilitates abusing children online. Is 178. Fifth, finally, when someone records in electronic form on abuse that of others pertaining to sexually explicit act with the children. Next topic, provision to section 67B is an exception. It lays down that the provision of the section 67, section 67A, and section 67B do not intend to any book, pamphlet, paper, writing, drawing, painting, representation, or figure in the electronic form. First, the publishing of which is proved to be justified as being for the public good on the ground that such book, pamphlet, paper, writing, drawing, painting, representation or figure is interest of science, literature, art or learning to or other objects of the general concern. Second, which is kept or used for bona fide heritage or religious purposes. It would also be opposite to foreground the newly added section 67C, which deals with the preservation and retention of information by intermediaries. The said section read as follows, page number 179. First, intermediary diary shall reserve and retain such information as may be specified for such duration and in such manner and format as the central government may prescribe. Secondly, any intermediary who intentionally or knowingly controverses the provision of subsection first shall be punished as an imprisonment for the term which may extend to 3 years and also be liable to fine. The insertion of this section by the IT Amendment Act, 2008, provides the central government, the necessary power to prescribe rules for the duration, manner, and format in which the intermediary has to preserve and retain the information. Withal, it also brings an intermediary within the gamut of contravention, and in the case of intentional default of any rules or direction, the intermediary shall be punished by imprisonment for a term which may be extended to the 3 years and along with a fine. Conclusion. Considering the type of cases which are surfacing, it is controvertible that the children are exceeding vulnerable and significant efforts from all the quarters are required to eliminate this peril of child pornography. The teachers, parents and the people having the custody of the child should be provided with a special training and apropos awareness regarding the pros and cons of the page number 180 high-tech modern world and social media. The interaction of parents and family members cannot be trivialized by the purpose of raising awareness amongst the children to such offences. The schools, media as well as the investigating agencies should work out impenetrable mechanisms for the prevention of such form of child abuse. The recent case where a 42-year-old American has been arrested in Hyderabad on suspicion of circulating child pornography on the internet indicates how the crime is devastating at every corner of the world. Besides, as per a report of India Today, according to the National Crime Records Bureau data, there has been a rise of the children being sexually exploited through internet imagery by 140% from 2014. Additionally, as per a report by Hindustan Times, updated on July 16, 2017, in a status report to be filed in the Honorable Supreme Court, the center has told that it is taking the help of US-based private body, which gives technical detail on uploading of the child porn to 99 countries to curb the menace in India. In a status report to be filed in the Honorable Apex Court, the center said that the US-based National Center for Missing and Exploited Children (starts NCMEC) acts as a resource center for information about missing and exploited children, and they provide free details through a secure channel to the central law enforcing agencies of the US and the 99 other nations. Page 181. In such circumstances, confronting child pornography in India requires much more than mere website blocking, and there is a parlous need to develop technological legal expertise in this field so that all the technical loopholes can be plugged in. Page 183. Next chapter 20, cybercrime in the news. So there is a quote said by the Socrates: "The secret of change is to focus all of your energy not on the fighting the old but on building the new." First, Mafia Boy. In February 2000, a 15-year-old Canadian called Michael Kalk programmed his botnet to hose down the highest traffic websites he could find. CNN, Yahoo, Amazon, eBay, Dell, E-Trade, all buckled, leading to the national headlines. and an emergency meeting of experts at the White House. Second, TJX. This is a MUSSACHUSSETTS hyphen based retailing company. Full stop. The parent company of TJ Maxx and Marshalls was one of the many retail companies which was hacked by the Albert Gonzalez. Full stop. The team of hackers were from Shady Crew. Full stop. This was one of the biggest, page number 184, cyber crimes in the history, and this crew was able to siphon 45 million from credit and debit card information. They used these huge amounts for buying electronic goods and many other religious things for the professional use. Third topic, presidential level espionage. This was another major crime, that is cybercrime, considering the high stakes involved. First up, during 2008 presidential elections, a group of suspected hackers attacked the computer systems used in the campaigns of both Barack Obama and John M.C. Can. This hacking included emails and other sensitive data used in the campaign. Fourth, Sony. In the year 2011, 77 million PlayStation networks and Sony online entertainment accounts for the credit and the debit card information were stolen by an unknown group of cyber hackers. It was estimated that the damage was an approximate $1 to $2 billions. Page number 185. Fifth topic is Epsilon. This is another significant cybercrime. As a result of this hacking, the data breach in Epsilon, which is one of the world's largest providers of marketing and handling services, had an estimated damage cost that ranged from $2 to $5 million to $4 billion. Sixth, friend finder network hack. In the biggest data breach of the year 2016, the user details of more than 412 million accounts were exposed to the data breach of the friend finder networks. In addition to confirmation of a 2014 breach at Yahoo that exposed a record of 500 million accounts, 2016 saw a string of other breaches, including the Daily Motion breach and the US Navy breach. Seventh topic, Tesco Bank halts. In November 2016, Tesco Bank was forced to halt online banking after thousands of current account customers were hit by the fraudulent transaction by the hackers, who managed to steal £2.5 million. First up, cybersecurity commentators say that the Tesco Bank theft shows need to take cybersecurity more seriously. Page 186. 8. Facebook profiles. As per the report of Times of India, creation of fake Facebook profiles, bracket starts, fake book, bracket close, form nearly 30% of all the cybercrimes registered in Bombay. Facebook formed nearly 30% of all cybercrimes registered in Bombay in the year 2016. A Mumbai police report further shows that cybercrimes, such as hacking, creating fake profiles and uploading obscene pictures increased by 30% in 2016. Ninth, blackmailing through emails. The accused posted to be a young girl living in Calcutta and lured as NRI, working in Dubai, bracket starts, complainant, bracket close, to enter into an email correspondence with her. Full stop. The accused began corresponding with the complainant using different email IDs under the guise of different female names, which made the complainant believe that it was corresponding with the different girls. The accused later started asking for money and gifts, but once the complainant stopped this correspondence thereafter, the accused resorted to blackmailing the complainant by referring to the email exchanges. In addition, the accused led the complainant to believe that one of the girls had committed suicide and that the complainant was responsible for it. The complainant lived in a, page 187, constant fear of being arrested and paid the accused a sum of INR 2.5 million ostensibly to bribe the officials that were supposedly investigating the suicide and to compensate the victim's family. Given the huge strain upon his financial resources as well as the mental agony faced by them, the complainant himself committed suicide. The matter was later investigated by the police and the total of the extorted money was traced from the bank in Dubai to the account of the accused. Charge sheet has been submitted in the case and the matter is sub judice. 10th topic. Receiving unknown offending calls from men. The complainant stated that some unknown person had created an email ID using her name and used this ID to post messages on 5 web pages describing her as a call girl along with her contact numbers. As a result, she started receiving offending calls. It was later revealed in the investigation that she had refused a former college mate who had proposed her marriage. Using this information, the investigating team with the help of Mumbai police arrested the suspect and he confessed to his crime. He was convicted of the crime and sentenced to 2 years of imprisonment and fine. Page 188. 11th topic. Fake travel agent. The accused in this case supposed to be genuine railway ticket agent and was purchasing railway tickets online by using stolen credit cards of non-residents. The accused created fraudulent electronic records / profiles, which he used to carry out the transactions. The tickets so purchased were sold for the cash to other passengers, full stop. On the basis of various complaints and on examining the passengers who had travelled on these tickets, the accused was arrested and presently the charge sheet has been submitted in the court of Mumbai. 12th, the 400 million SMS scam. The alleged mastermind behind a rupees 400 million SMS fraud that duped at least 50,000 people was arrested in Mumbai. 2 brothers were found involved in this case and they took help of SMS technology and launched the first of its kind, SMS fraud in India. They launched a catchy advertisement campaign in the print media that read, nothing is impossible. The word itself is impossible. As part of the attractive scheme, the 2 brothers messaged random numbers, asking people interested in earning rupees 10,000 per month to contact them. Interested subscribers were asked to deposit rupees 500 each. Subscribers who were registered with them, page 189, received about 10 SMS every day about the various products and were promised handsome commissions if they managed to rope in more subscribers by forwarding the messages. 13. Phishing attack to UTI Bank. A phishing attack was launched on the website of Ahmedabad-based UTI Bank, a leading private bank promoted by India's largest financial institution, UTI, Unit Trust of India. A URL on geosites that is almost a facsimile version of the UTI Bank's homepage is reported to be circulating amongst email users. The webpage not only asks for the account holder's information such as user and transaction login and passwords, but has also put up a tempting disclaimer and security hazard statements. In case you have received an email from an address appearing to be sent by the UTI Bank advising you of any changes made in your perusal information, account details, or information on your user ID and password of your net banking facility, please do not respond. It is UTI Bank's policy not to seek or send such information through email. If you have already disclosed your password, please change it immediately, the warning says. Page 190. 14th, credit card fraud on eBay. Rourkela police busted a racket involving an online fraud worth rupees 12.5 lakhs. The modus operandi of the accused was to hack into the eBay India website and make purchases in the names of the credit card holders. 2 persons, including alleged mastermind Debasis Pandit, a BCA student, were arrested and forwarded to the court of the Subdivisional Judicial Magistrate, Rourkela. 15th, abusive trolls. This case from Chennai relates to trolls who took umbrage with Thanya Rajendran to tweet that expressed her opinion about a movie. Thanya Rajendran, the editor of the News Minute, had tweeted on the August 4, 2017 that she felt that Shah Rukh Khan's new movie Jab Harry Met Sejal was worse than Tamil hero Vijay's film Sura. Within hours, there was a torrent of abuse from Vijay's fans that included name-calling, threats of rape and personal attacks. Page number 191, 16, movie piracy. As per the report of News18.com, updated May 16, 2017, a special cybercrime team in Hyderabad has busted a gang, allegedly involving in producing a pirated version of the latest blockbuster, Bahubali The Conclusion. This group also blackmailed the producers that they will release it on the internet. Police have arrested 6 members of this group from Delhi and Bihar. The complaint was filed by the producers stating that on the first day of the release, a pirated HD quality version of Bahubali was copied and they were blackmailed to pay lakhs of rupees to stop pirated version from being uploaded on the internet. This is the first such reported case in India where pirates were found to be blackmailing the producer. Topic number 17, MHA NSG websites hacked. The websites of the Ministry Home Affairs were hacked recently, prompting authorities to temporarily block it. The MHA website was immediately blocked by the National Informatics Center after hacking was noticed. Last month, suspected Pakistan-affiliated operatives had hacked the official website of the Allied National Security Guard, that is NSG, and defaced it with the profanity-laden message against the Prime Minister and other anti-India content. Page number 192, 18th, Cyber Police Stations, Maharashtra. As per news report of NDTV.com, Maharashtra is converting 42 state-of-the-art cybercrime labs into cyber police stations as per the government strategy to make on-crime cyber commitments. Maharashtra is facing increased cybercrime cases, and this new initiative will take care of the various shortcomings. 19th, harassment over social media. As per a report of the Press Trust of India, a man has been sentenced to 2 years in jail by the local court by harassing a minor girl and uploading her morphed, obscene images on the social media. In March 2015, the accused sent a friend request to the girl on Facebook under a fake name. When she refused to accept his request, he started sending messages to the girl. He uploaded some photographs from the girl's Facebook account and morphed them. He sent these images to the girl's inbox and managed to get her phone number. On March 17, 2015, he called the girl to threaten her that if he doesn't befriend him, he will upload the photographs on the social media. When she did not respond, he uploaded her morphed pictures under a fake account. On complaint, and case was, page number 193, registered against the accused under the IT Act and Protection of Children from the Sexual Offences Act. 20th, instant revenge and online pranks. As per a report from Indian Express, a school teacher in Mumbai central suburbs was recently informed by a student that he thinks that the teacher's Facebook account may have been hacked. He showed him messages sent to him via Facebook chat from the teacher's account. Shocked, she realized that someone has created a duplicate profile in her name with her photograph and other details. Worse, she found several other students had received obscene messages from this duplicate account. When she approached police, it was found that one of her students, whom she had reprimanded in the class, was behind a crime. Something he probably thought was a prank to extract revenge. The minor was subsequently arrested by the police. 21 NSC accounts phishing attempt. The email is purportedly sent from an ID webmaster.indianarmy@nic.in. The Indian Army has advised its personnel not to reveal the personal details through email to anyone without verifying the source of the email. The adversary is in response to reports of an email floating on the internet requesting for such details. The army headquarters has accordingly said, that a fraudulent email is circulating in the page 194 environment allegedly from webmaster, Indian Army, asking about personal details of NIC and IT users. The environment is hereby advised not to reply to this email, close. 22nd, Mumbai man loses 1.97 crores online. As per a report in the Times of India, the cybercrime police probing a rupees 1.97 crores cheating scam on the Bandara senior citizen by the Nigerian gang has found 108 fictitious accounts opened in the various banks in Mumbai using the fake PAN cards. First up, police found the gang has opened fake accounts in the various banks in Mumbai and Delhi. The accused transferred all the money to the other accounts, from where it has been already withdrawn. Police suspect Nigerian scamsters to be the masterminds. 23rd, RTI manager gets 6 years imprisonment in Puri cyber pornography case. As per a report in the Times of India, dated 4th August 2017, in a first ever conviction in cyber pornography in the state, Court of Subdivisional Judicial Magistrate in Puri on Friday sentenced an RTI manager to 6 years of imprisonment and imposed fine of Rs 9,000. The accused was arrested by the State Crime Branch in 2012 for allegedly uploading obscene remarks against a journalist's wife on a porn site. Special Director General of Police (Starts Crime) close, Shri B.K. Sharma said that thus defamed the woman to take revenge on her husband. Page number 195, who reportedly exposed his illegal money lending business. Shri B.K. Sharma further said that a technical inquiry clearly revealed that accused created a forged email account and fake profile in name of the journalist's wife. Accused linked the fake profile to a porn website and posted vulgar remarks against her. Accused also posted the journalist's phone number on the porn portal. Chapter number 21, The Blue Whale Challenge. The famous quote said by Buddha is, "The mind is everything. What do you think you become?" The Blue Whale game, or the Blue Whale Challenge, is believed to be a suicide game, wherein a group of administrators or a certain curator gives a participant a task to complete daily for a period of 50 days, the final task for which is a participant committing suicide. Participants are expected to share photos of the challenges or tasks completed by them. These tasks start off easy, such as watching a horror movie, among others, and slowly escalate to carving out shapes on one's skin, self-mutilation, and eventually suicide. So, schools, as well as police officials in Europe, America, and India have begun issuing advices to parents, urging them to be vigilant and to keep an eye on what their children sharing on their social media accounts. Page number 198. This database game has been created by a 22-year-old Russian named Philip Bedekin, who confessed that he was directly responsible for at least 17 teenagers in Russia committing suicide. The suicide of a 14-year-old Mumbai teenager on 29/07/2017 was suspected to be the first case of the Blue Whale Challenge-related suicide in India. This case marked fears that the dangerous self-harm game could have made its way in India through the social media. Recently, Manoj C. Manu, a 16-year-old boy from Kerala, hanged himself on July 16. It was informed by his mother that she suspects her son committed suicide to complete the Blue Whale Challenge. Moreover, as per a report from India Today, a 15-year-old boy in Bengal suffocated himself, and it has been alleged by his friends that he was playing the Blue Whale game. According to the family members, the teenager went to take a bath but did not open the door for more than an hour. His family grew suspicious and broke open the door only to find his face wrapped in the plastic sheet and a towel tied around his neck. Even the police is suspecting that the teen could have been influenced by the deadly peer group game that has taken the cyber world by storm. In another such incident, a class 7 student from Indore has allegedly tried to commit the suicide, and links to the Blue Whale challenge are being suspected. The student himself has confessed, page 199, that he had been playing the game called Blue Whale on his father's mobile. He said that he was afraid that his data will went viral if he didn't commit suicide. As per the creator of this game, he said in the interview that he gave those people warmth, understanding, and the contact, and that the kids who committed suicide because of him died happily. He further said, there are people and there is biological ways. Those who do not represent any value for the society, who cause only harm to the society. I was cleaning a society of such people. These news items show how an online game has triggered so many suicides among the youngest children, whereby it has been estimated that the Blue Whale Challenge has claimed around 130 lives in Europe and Russia, and has been a trigger for me to bring the present book into existence. The young teenagers have to be made aware of such potential and inviting threats online, which can virtually result in havoc and devastation. Full stop. I believe this to be my social responsibility and urge all the stakeholders and related readers of this book to join hands to protect our future generations from the cyber catastrophe. Page number 201. Conclusion. Chapter number 22. A famous quote by Winston Churchill: if we make a living by what we get, if we make a life by what we give. The day is not far when we will be completely surrounded by information technology in all aspects of our lives. The field of information technology is growing at a colossal pace in terms of its social significance. With this mammoth technology boost, each and every case of the related matter will have an information technology component, and one must have sound knowledge of information technology laws to stay abreast. The world of information technology can't ever be overplayed. It's a part of our lives in all manners. Be it operating our bank accounts, to ordering a cab, from payments, fund transfer, e-ticketing, to shopping for our daily needs. We're surrounded by the IT revolution. The Indian law in the internet age has evolved greatly, and by being cyber aware, we all can combat the deadly cyber crimes which is surrounding us, an epidemic. Page number 202. The Information Technology Act, 2000 is not being to be read in the isolation. This act has stepped in at just the right time to curb the menace of the cybercrimes. The book comes with a purpose to generate awareness, a purpose to be a reference to the students, teachers, paralegal volunteers, as well as everyone associated with the Legal Services Authority. I hope this work proves beneficial to whosoever intends to read it. I have attempted to state from my limited knowledge and vision, but without any reserve. I'm hopeful that this work would create awareness about the information technology law and acts as a bridge between the regular cyber user and the cyber czar.
To know more about Disha NGO or the audiobooks, contact on email disha.chandigarh@yahoo.com or call 9041 222282.
Please like this video and subscribe our channel for further updates.
Chapter number 21. The Blue Whale Challenge. The famous quote said by Buddha is, "The mind is everything. What do you think you become?" The Blue Whale game, or the Blue Whale Challenge, is believed to be a suicide game, wherein a group of administrators or a certain curator gives a participant a task to complete daily for a period of 50 days, the final task for which is a participant committing suicide. Participants are expected to share photos of the challenges or tasks completed by them. These tasks start off easy, such as watching a horror movie, among others, and slowly escalate to carving out shapes on one's skin, self-mutilation, and eventually suicide. So schools, as well as police officials in Europe, America, and India have begun issuing advices to parents, urging them to be vigilant and to keep an eye on what their children sharing on their social media accounts. Page number 198. This tier-based game has been created by a 22-year-old Russian named Philip Bedekin, who confessed that he was directly responsible for at least 17 teenagers in Russia committing suicide. The suicide of a 14-year-old Mumbai teenager on 29/07/2017 was suspected to be the first case of the Blue Whale Challenge-related suicide in India. This case marked fears that the dangerous self-harm game could have made its way in India through the social media. Recently, Manoj C. Manu, a 16-year-old boy from Kerala, hanged himself on July 16. It was informed by his mother that she suspects her son committed suicide to complete the Blue Whale Challenge. Moreover, as per a report from India Today, a 15-year-old boy in Bengal suffocated himself, and it has been alleged by his friends that he was playing the Blue Whale game. According to the family members, the teenager went to take a bath but did not open the door for more than an hour. His family grew suspicious and broke open the door only to find his face wrapped in the plastic sheet and a towel tied around his neck. Even the police is suspecting that the teen could have been influenced by the deadly peer group game that has taken the cyber world by storm. In another such incident, a class 7 student from Indore has allegedly tried to commit the suicide, and links to the Blue Whale Challenge are being suspected. The student himself has confessed, page 199, that he had been playing the game called Blue Whale on his father's mobile. He said that he was afraid that his data will went viral if he didn't commit suicide. As per the creator of this game, he said in the interview that he gave those people warmth, understanding, and the contact, and that the kids who committed suicide because of him died happily. He further said, there are people and there is biological ways. Those who do not represent any value for the society, who cause or will cause only harm to the society. I was cleaning a society of such people. These news items show how an online game has triggered so many suicides among the youngest children. Whereby it has been estimated that the Blue Whale Challenge has claimed around 130 lives in Europe and Russia, and has been a trigger for me to bring the present book into existence. The young teenagers have to be made aware of such potential and inviting threats online, which can virtually result in havoc and devastation. Full stop. I believe this to be my social responsibility and urge all the stakeholders and related readers of this book to join hands to protect our future generations from the cyber catastrophe. Page number 201. Conclusion. Chapter number 22. A famous quote by Winston Churchill. If we make a living by what we get, if we make a life by what we give. The day is not far when we would be completely surrounded by information technology in all aspects of our lives. The field of information technology is growing at a colossal pace in terms of its social significance. With this mammoth technology boost, each and every case of the related matter would have an information technology component, and one must have sound knowledge of information technology laws to stay abreast. The world of information technology can't ever be overplayed. It's a part of our lives in all manners. Be it operating our bank accounts, to ordering a cab, from payments, fund transfer, e-ticketing, to shopping from our daily needs. We're surrounded by the IT revolution. The Indian law in the internet age has evolved greatly, and by being cyber aware, we all can combat the deadly cyber crimes which is surrounding us, an epidemic. Page number 202. The Information Technology Act, 2000 is not being to be read in the isolation. This act has stepped in at just the right time to curb the menace of the cybercrimes. The book comes with a purpose to generate awareness, a purpose to be a reference to the students, teachers, paralegal volunteers, as well as everyone associated with the legal services authority. I hope this work proves beneficial to whosoever intends to read it. I have attempted to state from my limited knowledge and vision, but without any reserve. I am hopeful that this work would create awareness about the information technology law and acts as a bridge between the regular cyber user and the cyber czar.
About NALSA and the State Legal Service Authority. The National Legal Service Authority (NALSA) and the State Legal Service Authority has been constituted under the Legal Service Authority Act 1987 to provide free legal services to the weaker section of the society and to organize Lok Adalat for settlement of disputes. Article 39A of the Constitution of India provides that states shall secure that the operation of a legal system promotes justice on the basis of equal opportunity and shall in particular provide free legal aid by suitable legislature or schemes or in any other way to ensure that opportunity for securing justice are not denied to any citizen by reasons of economic or other disability. The Legal Service Authority provides free legal aid to the eligible person by woman, child, mentally ill or otherwise disabled, person in custody and other category as per the mandate of Section 12 of Legal Service Authority Act 1987. About the Information Technology Act 2000. Information Technology Act 2000 is an act of Indian Parliament notified on 17 October 2000. It is a primary law in India dealing with cybercrime and electronic commerce. It is based on United Nations Model Law on Electronic Commerce 1996, recommended by a General Assembly of United Nations by the resolution dated 30th January 1997. It provides legal recognition for transactions carried out by means of electronic data interchange and other means of electronic communication, commonly referred to as electronic commerce, which involve the use of alternative to paper-based method of communication and storage of information to facilitate electronic filling of documents with the government agencies. The Indian law in the international has evolved greatly by being cyber aware, and the deadliest cybercrime which are surrounding us as an epidemic can be combated. The present book seeks to generate awareness about the information technology law and act as a bridge between a regular cyber user and a cyber czar.
To know more about Disha NGO or the audiobooks, contact on email disha.chandigarh@yahoo.com or call 9041 222282.
Please like this video and subscribe our channel for further updates.